Yay. All persons having anything before the Honorable the Justices of the Appeals Court now sitting in Boston, far within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated.
Good morning. Thank you. All right. Good morning, everyone, and welcome to the Appeals Court. I'm going to start by introducing the panel. To my right is Justice Peter Rubin. To my left is Justice Maureen Walsh. My name is Ariane Vuono. We have some special guests here today. I understand that there's 8 interns from the Students' Legal Services Office from UMass Amherst coming to observe the first 2 cases. Welcome. I hope you enjoy it. I'm sorry we can't meet with you to talk to you a little bit about the cases, but maybe you will all be inspired to follow in our footsteps one day, and we'll have conversations at another point in time. I also hope you had a nice ride in today. It's a beautiful day. It's a good day to come to Boston. There's a couple of rules that most of you know about. Each of you have 15 minutes to present your argument. We've read everything that you've given to us, even those some things that were filed actually yesterday or today. We've received them, and we haven't maybe digested those filings completely, but we're certainly aware of them. Everything else that was provided to us earlier, we've read, and so you can get right to your most important points. I also want to remind everybody there is no rebuttal in the appeals court. That said, I'm going to start with the first case, and I hope I pronounced the name correctly. James C. MAZAREAS versus Peter MAZAREAS. Would you help me out with that, please?
MAZAREAS.
MAZAREAS. Thank you. MAZAREAS. 2023-0866. Counselor?
May it please the Court, Bill Sheehan for the plaintiff, James C. MAZAREAS. And so as to try to avoid confusion among the 3 MAZAREASes, I'm going to refer to the plaintiff as Jamie, his father as Jim, and his uncle, the defendant, as Peter.
That's fine. Thank you.
Count 1 of the plaintiff's complaint seeks enforcement of a contract to purchase 37 Lake Avenue for $301,000. Cross motions for summary judgment were heard by the lower court. The position of Jamie is that he is a third-party beneficiary to the May 2, 2015 agreement between Peter and Jim, and in that capacity had an option to purchase the property. He says he exercised that via his father's email to Peter on May 4, 2015. On cross motions for summary judgment, the court disagreed with our position for 2 reasons. First, the court concluded that the notice to exercise the option must come from Jamie personally and not through his father. And the second is that even if the exercise was proper, the court concluded that the submission of a purchase and sale agreement, which the court said was inconsistent with the terms of the option, vitiated the exercise of the option. With all due respect, the lower court was wrong as to those 2 issues. I'd like to talk first about the issue of the notice of exercise of the option.
Okay.
And most importantly, the language of that document does not require Jamie to personally give notice. Perhaps more importantly, the parties and their reaction to that May 4, 2015 email, because after all, the conduct of the parties helps the court in construing the meaning of that language, all the more so in this case, because it is the party's own language. It was not language of lawyers, but rather a handwritten agreement on a Saturday afternoon that was designed to resolve all of the issues between Jim and Peter regarding their parents' estates.
And yet here we still are, huh?
And here we are, 10 years later. And what's important, I believe, first is what Peter did not say when he received the May 4, 2015 email. He did not say, I need to hear from Jamie personally. He did not say, well, Jim, do you have the authority to bind your son Jamie? He did not say, well, the notice is great, but I need $301,000 by today. He didn't say any of those things. And he didn't say, well, what does your email mean? Peter knew what it meant. He knew it meant it was an exercise of the option. And his reply very simply was, good, in response to the notice of exercise of the option.
Well, his response, I'm sorry, go ahead.
If we were to accept your argument for now, Does it matter? In other words, was there a modification later on?
There was no modification, and it does matter, and I'll certainly address in just a couple of minutes the notion of the purchase and sale agreement and whether it was a modification. But just to finish up on the notion of the party's reaction to that May 4, 2015 email. Peter contacted the broker to contact the third-party buyer to dismiss the third-party buyer. He would not have done that if he hadn't understood that the option had been exercised.
Okay, well, I don't know, obviously, if that's true or not. That's conduct after the signing of the contract and the purported exercise of the option. But let's say with or without the conduct of Peter in response to this on that same day, let's say I agree with you that notice is good enough. You don't have to tender $301,000 2 days later, and that you can exercise the option through an agent, and that Jim was Jamie's agent for that purpose, and the option was properly exercised. Jamie sends through Jim a purchase and sale agreement. Obviously, it has to be substantially equivalent. Let's say it is. I understand there's a mortgage condition, and so your brother's position is that it's not substantially equivalent. But let's say it is substantially equivalent. They have 90 days under the statute to get their financing in order, and on that day, they're going to have $301,000, or they're not. So, okay, let's say it's substantially equivalent. The next day, Jamie's lawyer contacts Peter's lawyer. Peter says to Jim, let's just leave it at that. Peter says to Jim, what is this all about? Why is a lawyer for Jamie, P.S., who the estate is paying for, why is that lawyer contacting my lawyer? We have this agreement. He doesn't quite say the option has been exercised, but he's like, what's this all about? I was going to respond to your P&S, but now there's this. And Jim, and I'm going to put this in parentheses, acting as the agent for Jamie, says there's a problem with the settlement agreement. Jamie is going to need, it says sign off. I don't know if it means releases or actual documents. As a trustee of the trust, so I'm not sure exactly what he's asking for. They're the beneficiaries. But he's going to need sign off from all the other beneficiaries. Now, it is true that Peter responds that that should be no problem. But if that's a material term, and I'm inclined to think it is because it requires agreement of a bunch of people who aren't parties to the settlement agreement, why isn't that essentially revoking the the exercise of the option and saying, no, I want something else in the option contract, then I'll accept it?
Jim was not acting as Jamie's agent on the 5th.
How am I supposed to know that, and how would Peter have known that?
Because Peter wrote to Jim on May 6 and made sure that Jamie was still interested in purchasing the property. And there was an email.
He is still interested, says his agent, Jim. But his agent, Jim, also says he needs sign-off from these other people, the cousins and the sister.
What Jim said to Peter was that his lawyer, Jim's lawyer, suggested that the agreement, the May 2, 2015 agreement, was not a binding agreement because there were others who allegedly had to be parties. That was what Jim said to Peter, and Peter understandably wanted to confirm that Jamie did in fact want to go forward, was exercising his option to purchase. And that was confirmed on May 6. And once again, Peter was satisfied with that, and Peter then took the purchase and sale agreement that was sent to him and said, "I will send this to Ned," referring to his lawyer. And again, what's interesting is Peter's reaction, just as his reaction to the notice being exercised is important, so too is his reaction to that purchase and sale agreement to respond to Justice Walsh's question. Peter did not see that as a modification of the agreement, and in fact, it wasn't a modification. It was not unusual to have a purchase and sale agreement that would have additional terms, but there was nothing in that purchase and sale agreement that was inconsistent with the sparse terms of the option.
But Jim says in this email, there's a problem. He's not going forward. The real question that Peter asks him is, what's this all about? Aren't we just going forward? And Jim says, no, there's a problem. All the beneficiaries need to sign off.
And Jim is talking about the agreement, the May 2, 2015 agreement in general, and Peter wants to make sure, and does make sure, that Jamie is going forward with the purchase of 37 Lake Avenue. And he confirms that on May 6, and the parties go from there. There is no question that the reason Peter didn't sell to Jamie through at least December of 2015 was Jim's, most unfortunate from our point of view, interference by claiming that the agreement, the May 2, 2015 agreement, was not, somehow was not binding, which Peter said, of course it's binding, and which the probate court said it was binding.
What did Jamie say?
Jamie was not a party.
I'm not asking what he said as a party. I'm asking in the record, what's the next communication between Jamie and Peter? Peter hasn't responded to his P&S, although he did say something in an email to Jim, who 24 hours earlier had been acting as Jamie's agent. So I'm not sure what we're supposed to do with that. But he does say, I was about to send this, and then we get a call from Jamie's lawyer. What does Jamie do? What's Jamie's next act? Because it's 10 years now. So I want to know what Jamie does right then in order to continue his functioning with Peter.
The record does not reflect what Jamie did immediately, but I can tell you this, Your Honor, that Jamie had some kind of communication through his lawyer, Jim Moore, with Peter's lawyer.
It's not in the record, though.
Well, it is.
Okay.
It culminates in a January email, January of 2016.
2016. Okay, it's like a year later.
Well, it's a number of months later, but it's right after.
Right after a judgment that says this is, I don't know if it says this is an enforceable agreement or go write a new agreement.
So what the judgment enforced over Jim's objection, the judgment enforced the May 2, 2015 agreement. And the attorney for Peter wrote to the attorney for Jamie and said, as soon as that judgment is final, we will convey the property to you. So that at no time was Peter taking the position that he was not going to sell.
What day did Jamie send a check to Peter for the property?
I apologize, Judge.
What day did Jamie send a check pursuant to the P&S to Peter to buy the property? He gets a letter saying, we'll convey. When does he send the $301,000, even less the, let's leave, I mean, that's a complication, but less the money that maybe the December 2015 judgment shows what the right amount is. When does he send a check to Peter?
He never sends a check to Peter, and he doesn't send a check.
Why?
He doesn't send a check to Peter because Peter reversed his position in April of 2016.
But you said in January, he said, the lawyer said, this, whenever this is done, and you had a final judgment actually in December, right?
Right. And if
All right, so why didn't Jamie send him the check? Oh, final judgment, awesome. I guess we're good to go. Here's my, whatever it is, $200,000 something dollars.
Well, the answer to that question, Judge, is that the parties did not immediately, following the enforcement of that judgment, The parties did not get together and hold the transaction. And it was in April.
So do we have to figure out whose fault that is? Is that the question before us?
No, it is not, because in April of 2016, we know why in April of 2016 the property wasn't sold, because at that time Peter was looking for various releases. And we know in September of 2016, after Jamie had sent a couple of purchase and sale agreements, the same agreement, sent it twice, we know in September of 2016, Peter said, well, I'm not going to sell it now because your father owes me $38,000 ordered by attorney's fees.
Okay, I've spent a lot of your time, and I want to let others have it.
Can I just ask, to make sure that I'm clear, because there certainly seems to be very fact-driven in this case, but do you agree that the standard from which we review is an abuse of discretion?
It's abuse of discretion only as to the issue of judicial estoppel. It is a de novo review on the two major issues here, because it is summary judgment, and it's reviewed on summary judgment. Didn't get to a number of things that I wanted to get to, but let me just make sure that I've answered Your Honor's question regarding a modification of the purchase and sale agreement. The parties didn't see it as a modification. The parties, Peter again never said, well, this isn't the agreement we have or anything like that. In fact, what he says is, through his lawyer, as soon as this agreement, as soon as the May agreement is enforced, we'll be ready to close. So with all of those things, happily I've addressed, I think, all of the other issues in...
Well, nothing is waived. Of course, all of your arguments are set forth in your brief, and we're familiar with them.
Thank you, Your Honor.
Okay. Just 1 second, though. Any further questions?
No, good.
Thank you very much. Counselor.
May it please the court, my name is Timothy Perry. I represent Peter MAZAREAS. I'll refer to them by their first names as well for convenience. I think the question that is still unanswered is what Jamie said, or what Jamie did during the 3 years and 3 months from the time that the option was supposedly exercised, and in this suit that they filed 3 years and 3 months after that exercise, they claimed that the option was fully enforceable as of May 4th. Jamie did nothing. Jamie has never said that he exercised the option. He engaged in communications after the option was supposedly exercised.
Why is that relevant to the appeal that's before us, what the parties did after or failed to do?
Well, because I think it's seminal to what they're arguing, and I think that Justice Rubin asked the question.
But our role, I understand
Yep.
Justice Rubin's point, and I agree with it, but our role is to review what the judge did and what the facts were before the judge, not what happened later, because the judge that made the decision didn't have the benefit of that evidence, correct?
The judge most of that information is in the record, but I would say you're correct. The judge made the correct decision based upon the option itself, and whether there was an effective exercise of the option, and whether that purchase and sale agreement changed the terms of the option and therefore was an engaging in further negotiations. All of the case law is very clear on that. When this supposed exercise of the option, all it says from Jim, not from Jamie, but Jim says, Jamie wants to exercise. Sorry, he didn't even say exercise. Jamie wants to purchase the property. I'll get you a P&S.
Okay, but your client and Jim entered a bare bones handwritten contract that doesn't say notice isn't good enough, notice through an agent isn't good enough. We're supposed to imply reasonable terms for everything that you haven't put in. And on the day, 2 days later, both his father calls and says he wants to exercise it, maybe acting as his agent, and they send a P&S. And if the one of those things might be good enough to be an exercise of the option, I find it very unlikely that Uncle Peter wanted Jamie to come over with a pile of $301,000 2 days later. That tendering cash seems like an unlikely thing to have anticipated in all the facts and circumstances here. So how do you exercise an option that says exercise the option? You either say, I will buy the property, maybe that's the notice, maybe the P&S if the first one isn't good enough. And I understand the P&S, you now argue, was problematic. But Peter never said that. He never said, yeah, this is fine, but I dispute the amounts of these set-offs. Or the set-offs are separate, or nothing like that was ever said. And I read that email exchange from the next day, frankly, to be, I mean, it makes sense. Peter has now dismissed this real cash offer from some third party and wants the $301,000 for the trust, just like he should. But he acts like, yeah, it's fine. What is it? We got to tweak this detail of the sign off by the cousins and the sister. All right, that shouldn't be a problem. Maybe that's further negotiation. Maybe it isn't. And then he goes even further, and a week later goes in and sues, saying this is an enforceable agreement, the underlying agreement. So how has he rejected ever this exercise of the option, if it is that?
And there's a lot there, and I'll try to take it piece by piece. And with respect, and this is in my brother's papers a lot, that somehow Peter has an obligation to reject, and that's just not the case. I mean, the case law is, number one, to answer your first question, they decided, they both had lawyers at the time, they decided to forego their lawyers and to draw up this handwritten option. Well, it's a settlement agreement that was supposed to settle all of the 4 cases. That probably was not advisable, but when you do that, you live with the consequences of that. And what the case law is very clear in saying, and I've cited the case law, and the trial judge had the same problem you had with enforcing this strictly and saying that it had to be exercised by payment of the purchase price. But they decided to write the option that way, and the case law is not confusing at all. Maybe they didn't know the case law, but ignorance is not an excuse. The case law says if you don't say that notice is sufficient, then you have to show up with the purchase money.
So you're saying we do not imply a reasonable term. You're saying built into a bare bones contract with an option in it that is written leaving out a million terms, but including, the judge says at least, the material terms, that we don't have the option to look at what's reasonable in the facts and circumstances. We must treat it as cash being proffered 2 days later.
I believe that because that's what the case law says. All of the case law in the court below cited the case law, as I have in the brief, that says these options are unilateral in favor of the option E. And for that reason, they're strictly construed. And there is, I mean, every contract, reasonableness is inherent in the contract. But if the parties agree under the law, that's what they live with.
Even though Peter did not conduct himself in accordance with that. Even though Peter did not thereafter conduct himself in accordance with this, what you and the judge have referred to as a strict compliance with the option.
Well, I disagree with that respectfully, Your Honor, and because I think the May 6th email, I think that Justice Rubin mentioned earlier, it's Appendix 2, page 218, between Peter and Jim, includes this statement, quote, "Is Jamie in agreement? We haven't heard directly from him. If he is in agreement and wants to proceed with the purchase, he needs to send a statement today to that effect and speak for himself, as he is an adult and has a real estate agent's license. Once I receive that, we will send Jamie the reply to the PNS you submitted. If not, then I'll proceed with the other buyer as I am under a hard deadline. I'm not clear Jamie is in agreement, so please respect my wishes and have Jamie speak for himself." What they're saying there is not that this option was exercised and enforceable, and you'll never see anyone say that the option was exercised as of May 4th. What he was saying was, you've provided me a PNS, I'll get back to you with the PNS. And respectfully, the PNS is completely different in terms than the option, which required $301,000. It wasn't just the financing contingency, which also varied in the terms, because that would have allowed the optionee, who has a unilateral contract, to also take another 90 days and then just back out of the deal. It also provided him a contingency for inspection, which wasn't in the option, and it provided $130,000 in credits, and this is what the trial court found to be most convincing, as do I. It's only a $301,000 purchase. So he's asking for credits, none of which are, with due respect to my brother, who argues in his brief that those are all contained in the settlement agreement. Not one of those credits are contained in the settlement agreement.
The amounts aren't there.
I don't even know which credits they're talking about, because there's arguably one of those credits is referenced about attorney's fees.
So let's keep going. So then a bunch of things happened. Jim fights against the agreement. I don't know if Peter thinks Jamie, as Jim's son, is also on that side. I don't know. I mean, you say he was a party, but really he just filed an objection in the first place. It's not much of a party, and it's not party to the other cases that are consolidated with it. We go and go and go. It's December of 2015. The court says that it's going to enforce this, although I do see that there's a new handwritten agreement or something around the same time. And Peter still says in January of 2016, yeah, when this judgment is final, we'll do the transaction.
Right. So that's the result of further negotiations, and this is part of the point that we've made in our papers. Nobody's acting as if this option has been exercised. The references when there was court hearings, at which Jamie was there. And if Jamie has...
Well, sitting in the audience isn't, as your brother points out, isn't quite the same as being a party.
He was a party to those 4 suits. They had been...
He was a party to one of them.
The suits were consolidated.
I understand that. He was a party to one of them.
Okay. And, well, let me put it this way then. He sat there through all those hearings. Hearings, some of which his father was saying, my client was in contempt because he didn't observe the option. And he never stood up for 3 years and said, I have this option, it's enforceable, I have rights, why aren't you enforcing my rights? He waited for his father to do that for him.
Although Peter kept saying, I'm going to sell to you for 301 until, if I had to guess, its value went up.
Well, there's no question that the value went up, but he wasn't saying there was ongoing negotiations. And that's the problem with you saying you exercise an option, but not either showing up with the purchase price or shortly thereafter submitting the purchase price and getting it done then, when maybe it could have been beneficial to the estate. Because the reality is Jamie's only one of 6 grandchildren. Okay, so he was getting a windfall to begin with, but there was all these disputes, and they were trying to settle all
Only
disputes.
getting a windfall if it's not a fair price.
Well, no, he's getting a windfall because the other 5 would split this asset. If it was just sold on the open market, that $301,000 would have been distributed to 6 grandchildren.
Sure.
Instead, he's getting it because there were these disputes, and Jim and Jamie were arguing
The
about
money still goes into the trust and is split 6 ways, isn't it?
No. Well, the 301,000,
Yeah.
but he's getting an asset that's going to be worth more than that himself. So,
I mean, I don't know he's paying for it. There was a third party who would have had the asset by paying for it, so I'm not sure it's a windfall. You know what I mean? I'm not sure that it's a disproportionate share of the estate.
fair enough. But Jamie himself never once said that there was an exercise of the option. And those, I do want to make a point about the hearings before the judge, because the judicial estoppel argument, I think, is the one that my brother leans on in his papers. 2 things have to be shown: that we took a different position, and then secondly, that the judge in that proceeding relied on it and made a ruling based on it. The position that they say that they took at the July 7th, 2015 hearing was just that we were told that he was going to exercise the option. No one said, rock solid, this thing has been exercised. And so to cherry pick that one hearing, particularly where then they move for contempt repeatedly, saying specifically he failed to convey the property even though the option's been exercised. And Judge Besenius, 3 times, once she dismissed it and twice she found Peter not guilty of it. So her finding was that the option had not been exercised. So for those reasons, Your Honors, I think that the court below clearly made the right decision. There's nothing to overturn here, and this matter needs to be closed after the 10 years of these disputes between the parties.
I see no questions from the panel, so I thank you both for your arguments.
Thank you, Your Honors.
And we'll see what we can do after 10 years. Okay. The next case is John Doe, number 523735, versus the Sex Offender Registry Board, number 2023-0218. And I remind the attorneys and ourselves that this case is impounded.
Good morning, Your Honor. May it please the court. Fred Burkholder on behalf of John Doe, 523735. My argument in essence is this: there was no empirical support for application of Factor 2 after the court's decision in 22188, which the board assented to and did not appeal. And then the question is whether or not the language as narrowed still allowed for application of that factor under these facts. And my contention, it does not, and my further contention is that there's support, although in an unpublished opinion, but from this court that says the following, and I think it's important. It says, the examiner equated the question from wife's with being confronted with the meaning of the regulation. On remand, the examiner should address how this characterization is consistent with Factor 2 and the scientific principles on which it rests. The point is basically this. Certainly, as in 6729, if there was a prior criminal conduct and then a subsequent offense, I wouldn't be talking. But that didn't happen here. So now we have some language out there that's ambiguous. We don't know what it means. My brother says, well, there's nothing to say what it means. My argument is the court in 22188 already looked at Dr. Hansen's testimony and said, basically, it's unclear whether or not confrontation by a family member is going to be predictive of risk. Obviously, a panel of this court felt the same way because they wouldn't have sent it back. So to just now try to say, well, just because my client said, well, I couldn't control myself around victim 1, that's evidence of compulsion, and therefore that factor should be applied. I don't think that there's adequate evidence in the record to support that, both from an empirical standpoint as well as an expert standpoint. And I'll tell you what came to mind this morning when I was finishing preparation was this. When you make that statement and you equate it to compulsion, you almost equate it to the existence of a paraphilia. That applies Factor 1. And there are already decisions out of this court that say, and I just got one recently, that says if you're going to apply factor one, you got to have an expert. There's no expert in this case. So to simply make that off-color remark, which the Superior Court did, that because he said that he has a compulsion, I don't think that's enough evidence either. So where does that lead me? That leads me without application of factor two. Now, why is that so important? Because when you take that out, then you have to start looking at the other high-risk factor, factor three. Now, I know this case has been before the Court of Appeals in another session previously, and I know at that time there was a finding that the hearsay from victim two was in fact credible. I'm not going to challenge that.
Liable.
I think I'm stuck by it. I understand that. But what I can say is this. When you take out factor two, then under 22188, there's a test that has to be applied. First of all, do the remaining factors clearly dictate? And that's where I think we get stuck in this case, because I think when you take out that factor, then you're looking at somebody who, although their testimony not testimony, but statements in a police report are deemed to be credible, I think you have to, when you balance something, you have to look and see the weight of that evidence. That's what the hearing examiner is required to do. And I think that there's less than increased weight that should be applied to that factor based upon the source in which it came.
So you're saying it's an abuse of discretion because there was too much weight placed upon that factor?
Yeah, I think if you place too much weight upon factor three, then of course it tilts the scales to some degree. But if you look at the remaining factors that are deemed applicable by this hearing examiner, when you take out factor three, there isn't a whole heck of a lot left. We have intrafamiliar victims, we have basically threats, the situation in which it occurred, and the penetration. So I'm not saying that what my client did was give him a gold star.
But how can you say that's not enough when you just the recitation that you just made?
And you left out prepubescent victim.
Without any question. Without any question. But you have to look at the length of time that passed since the offenses occurred. You have to look at the other potential aggravating factors that could be present, such as the existence of substance abuse, such as a potential criminal record or otherwise. This guy doesn't have all that.
Hold on.
Let me interrupt for a moment. It appeared in your appeal that there was no disagreement that the hearing examiner properly applied the mitigating factors. The question was whether or not the hearsay evidence was substantial once it was stripped away, and the second underlying issue was whether the hearsay was substantially reliable. Two separate factors that we need to determine upon review, correct?
Exactly.
So the issues of the mitigating factors, the length of time that he's been crime-free, et cetera, they're not argued before the court. That's a given. And it seems to me that the two challenges you have is one on the overall constitutionality of factor two, which you requested a declaratory judgment upon, right?
I did, but the more that I think about it, I think it should be deemed as an as-applied challenge rather than as a actual challenge to validity, simply because I think it's been decided by 6729.
Okay, so you're waiving the declaratory judgment portion of this and focusing in on, as to this particular client, in case, that there was an abuse of discretion because once we look at the facts that the hearing examiner properly could weigh, it doesn't amount to substantial evidence. I just want to make sure that I'm focusing in on the right legal argument.
I think you have it as
You're waiving your
as precisely as I could.
You're waiving your declaratory judgment claim.
Well, I mean, here's the problem with the declaratory judgment action. First of all, I think it's been decided by 6729. I mean, that case said factor two is constitutional now based upon the changes that
I thought you wanted a declaration that it couldn't be used where it's a family member who does the confronting.
Well,
I have to look again at your papers.
Here's what I'm going to say. I'd love to say I don't waive it, but the way that it's argued by the Superior Court, and I'm sure my brothers are going to say the same thing, is it has to be brought in a separate declaratory action, and
Why does it have to be brought in a separate declaratory action?
That's what DO 10800 says. However,
The Wilkins case, it wasn't brought in a separate declaratory judgment action?
Exactly. And that's what my argument is. It was not. But the question becomes how much this court is going to rely upon 6729 to find it constitutional. Because it says, that language is still in there that I'm challenging. It's still in there when 6729 analyzes it, and it says it is constitutional. So, I mean, is my argument moot? I got to believe that it is, because the same language was in fact addressed.
I just want to make sure that I'm clearly addressing the legal issue before the appeals court today, which is, as applied, the judge committed abuse of discretion in making the determination that substantial evidence existed for your client to be deemed a level 3 sex offender.
That's correct, Your Honor. And there are several components to it.
And the basis of that is still Dr. Hansen's letter, or no?
Yes, of course it's Dr. Hansen's letter. Because 6729, in the language, it says that it's consistent with Dr. Hansen's opinion. But the opinion that they are referencing is that if there's a prior criminal prior court conduct and then a subsequent offense, that clearly it's indicative of compulsiveness. That's the component that it addresses. My argument is, under his letter, which I attached as an addendum both in the Superior Court as well as in this court, says specifically the following. It says, it is unknown whether reoffending after confrontation by family members, for example, would be a valid indicator of increased risk. That's my argument here, and that's the argument that was picked up by the court in 524184.
That's the remand one.
That's the remand.
Has there been a decision on remand in that case yet?
I found nothing, but I mean, I looked this morning, and I can't tell you I spent hours and hours. I mean, I punched it in, and I saw nothing, but, you know, I'm certainly fallible. The other argument I want to talk real briefly about is this. Okay. You got some, my brother makes an argument two ways. He says, first of all, when I'm talking about degree of dangerousness, the board doesn't have to consider probation terms. Then he says, in the next paragraph, but they did consider the probation terms. Mm-hmm. My argument is, when you don't have any violations of probation in existence, you have no other criminal record other than these offenses, you're placed on 10 years of probation, and then one of the terms of probation includes no contact with an individual under 18 years old, then I think that those factors should be considered. And I think when you have an intrafamiliar history, that's got to also be considered when you're doing degree of dangerousness. And when you look at all those things together...
But you have a spouse who denies that the crimes occurred and may be less than vigilant in preventing her own family members from being anywhere near Doe. And I understand there's a condition of probation, but sadly, we see people violate those kinds of conditions day and night.
I totally agree, but I want to just bring the court's attention back to the language in the police reports that existed. And this is the circumstances and the scenario in which his wife is forming her opinion. All right? Sure, he got convicted by a jury, but she's got to also take a look at what was said, and those police reports are conflicting without any question whether or not who was told, whether or not the victim two was in fact lying, when the supposed statements were told, etc. So
Can't we presume that she's not relying on police reports to form her
She
opinion?
didn't see anything. There's no reference that she saw it.
Do you think her husband might have ever talked to her about this?
I
They live in
wasn't
the
there,
same
and I
house.
can only deal with the record.
They live in the same household.
I don't disagree, but I can only deal with the record, and the record doesn't say she saw anything. Just like in...
But you also agree with the record, and you're drawing an inference from the record. And your inference you're drawing is that she's clearly that this comment that she's making, I don't believe it happened, must come from a discrepancy in the police reports. And another person could draw the inference that perhaps she simply doesn't believe the victims, and she.
Without any question.
Okay.
No, without any question. I can't dispute that. All that being said, and although people violate probation all the time, this guy has not. And this guy doesn't have a criminal background.
He does have a criminal background, two very, very serious crimes.
Of course he does, but you know what I'm trying to say.
No, actually, I don't. You just said he didn't have a criminal background, which is absolutely, excuse me, not true. So let's be clear, all right?
Under factors 10 and 11, they look and see whether or not
No, but if we're looking for whether he's going to violate probation, and obviously I hope he doesn't, it's a crime.
I'm not trying to argue with Your Honor, but with all due respect, the hearing examiner did not apply factors 10 or 11 in this case.
That's a different point.
But they weren't applied, so I have to deal with what I have. All right, and that's what I'm suggesting is they weren't there. You know where I'm going with this, and that is when you have an intrafamiliar victim base, do you need to blast it on the internet, and do you need the police knocking on doors next door? This guy might be a level 2. I certainly believe he should be no less than a level 2. I don't agree with his conduct. I think it was heinous, and I don't disagree with anything that this court has indicated with regards to how severe it was. But we have to look at what his victim pool was. We have to look at what's going to restrict him in the future, and whether his wife is going to say yes or no or otherwise, he's still got some restrictions that are in place. And he's got a limited victim pool.
Let me back up for a moment. Seeing that time is of the essence. I don't see, and if you could point me to, I would appreciate it, anywhere in your brief that you argue factors 10 and 11. When I reviewed all the documents, and I want to make sure again that I'm clear, I see your argument about factor 2 as applied. And I don't see this new argument of factor 10 and 11 not being weighed properly by the hearing examiner. Can you point to me in your brief where?
No, because it's not there, because the case law says you're not to talk about factors that are not applied. Because briefs used to say back in the day when I started this and even before, attorneys would come forward and say, well, he didn't violate this factor, he didn't violate this factor, he didn't violate this factor, he didn't violate this factor. And finally the court said, we don't want to hear about all that. All we want to hear about is the factors that were applied. I'm saying they weren't applied. My statement has been he doesn't have a criminal record. Of course he does. I'm not stupid, all right? I know he has a criminal record. But other than these sex offenses, he does not have one. That's why factor 10 wasn't applied. That's why factor 11 wasn't applied. Now, when you're balancing somebody, you still have to look and see what are we left with balancing. What are we left with? We're left with his offenses, child victim, and now we're left with the 3 other factors, which were the situation in which it occurred, the penetration, and then the number of victims and their age. That's all the factors, that risk-elevating factors that are present.
Thank you.
Your time is up. I'll just see if anyone has additional questions. No.
No.
Thank you very much for your argument.
Thank you.
We don't think you're stupid. At all.
If it pleases the court, David Chennai for the board. I argued 10-800 back in the day, and Justice Spina, I think, kind of, when he wrote that you had to have a separate action for declaratory judgment, there was lots of disagreement in the legal system throughout all the courts. And it's kind of gotten blended into these MJPs. But the bottom line of a declaratory judgment is the burden is on the affiant bringing it forward to prove that the regulation or statute is unconstitutional. And merely citing Dr. Hansen's 1998 statement that he made in a report doesn't do that. Now, I'll be honest, I argued 6279, although the court did say that the second portion of that is constitutional, the issue about a family member confronting was never directly addressed. They basically said at that point, all of the second portion is constitutional. So the burden would be on the offender's attorneys to then begin the process of attacking that portion of it, and that would have to be done by showing that there's actual studies that say that the board's regulation is inconsistent. Excuse me?
You could have a trial.
You could have a trial on it, or at least bring in some type of research that undermines that portion. If that hasn't been done, I'm not sure there is any research that undermines that portion of factor 2
Or supports it.
or supports it. It's kind of in that limbo area.
Oh, okay, but unsupported is no good, right?
Well, it is in the sense that the board has the authority to draft regulation that is in accordance with the statute.
And scientific reality.
Well, it doesn't necessarily, I mean, there's case law that says every single factor doesn't have to be based on science. I think I don't remember which case, I want to say it's 10216 from 2006, or it was Doe versus the Attorney General. It's one of the two in 2006. And that case basically said that they were looking at, I think it was factor 19, that didn't have research attached to it, and said specifically, you do not have to have research for every single factor.
Well, but for this question of whether being confronted by a family member, in fact, has anything to do with risk of recidivism, no one has ever said that. I understand it as the word confronted by another person. But the question of family members, and there is this thing, I mean, it's Dr. Hansen. I don't know, that's, so far as I know, and all I know is the case law, that's like all there is. That's as good as it gets.
Right. And so I'm not sure the question.
Well, I guess my question is, I mean, there was no finding of fact in this proceeding about whether it's scientifically supported or not. Was there?
Well, you wouldn't have that because the hearing examiner doesn't make scientific findings.
No, but in the trial court, you can, just like in the Wilkins case, you can challenge whether there's any scientific basis for it. I mean, there maybe it was more also, can you say it's compulsive if it's just repetitive when there's two different words?
Correct.
Right.
I mean, I think the Superior Court, when it went into the idea of compulsiveness, really was outside of its realm. That really wasn't the issue. The issue is factor 2. Was it applicable as written without proof that the portion that was used is unconstitutional? And in going into the Superior Court, it was up to that point, and even in the Superior Court, it wasn't attacked on constitutional grounds. So the court really never addressed that issue. The compulsiveness of it, I admit the court, I think, erred in bringing that up, but the most important part is whether factor 2 applied. And as it stood at the time of the Superior Court, that portion of factor 2 was applicable and was supported by Doe 6279, because the court in that case did have the authority to say that portion is not constitutional, and they didn't go into that.
But didn't your brother raise in the Superior Court a challenge to the constitutionality of applying this factor to a family confronter?
Correct.
Okay. So if we don't find that it's a matter of indifference, right? If we find if factor 2 wasn't applied, we'd remand it and let someone look at it again. If we find that, don't we have to send this back to the Superior Court so they can figure out whether there's science behind this or not?
Well, no, because although the challenge was made, they did not produce any scientific evidence at that time.
The letter from Dr. Hansen, I don't know what you want to call it. It may not be peer-reviewed, but it's a letter from Dr. Hansen. It's something.
Right, but at the same time,
you wouldn't do judgment on the pleadings.
Excuse me?
You couldn't do judgment on the pleadings given that letter because it would raise a question that has to be probably tried.
Right. And that's the issue in this case, is that when it was in the Superior Court, it was the letter from Dr. Hansen and the assertion that that proves beyond a reasonable doubt that
No, you say beyond a reasonable doubt, but the case is, I mean, Wilkins didn't find beyond a reasonable doubt, right? I don't see that as the standard.
Yeah. I like to say beyond a reasonable
Sure,
doubt. It
I do
sounds
too,
good.
and in a criminal case, that is the standard.
So if I could just focus for a moment, and we can have a difference of opinion as to whether or not the judge was correct in denying the declaratory judgment process for a claim of constitutionality. But as applied to this case, can you present your argument as to why the judge or the hearing examiner really got it right?
Because there was proof evidence that the hearing examiner accepted, and again, the standard for accepting it is by a preponderance of the evidence, and the hearing examiner looked at it and found that on 2 occasions, the wife confronted her husband about the sexual abuse against his daughter. And the first time, and I think it's important that the first time the sexual abuse stopped for a period of time, then it resumed. The wife again confronted the individual, who then threatened his daughter never to tell anyone again, which are actions consistent with someone who had been confronted by somebody and still continued to commit sexual offenses.
But you're eliding the issue raised by Doe below, which is, yes, of course you're entitled to find that my then wife confronted me. That's fine. I'll agree that it happened. But that's not predictive of increased risk of recidivism because there's no science behind it. And what's your answer to that question, given that there is in the record this letter from Dr. Hansen, conceding maybe that there might be something that you would have if this went through discovery or whatever, that points the other way. I have no idea what the truth of the matter is.
And again, I go back to the board's regulatory authority to draft legislation, regulations that are consistent with the intent of the legislature, which factor 2 is. Now, again, the burden is on the other party to prove the unconstitutionality of that portion of the regulation.
So he's raised it, and he has what I'm going to call some evidence that it's unconstitutional, that it doesn't actually predict anything.
But that's
now what?
Well, that's different. It's some evidence that doesn't prove the unconstitutionality.
No evidence on the other side.
And that's why a declaratory judgment is a much better vehicle for this, because they can have a trial.
You don't say in your brief that declaratory judgment is impermissible in this circumstance. I know there's a case that said it from a long time ago,
right.
But Judge Wilkins heard, I don't know why that would be right, but Judge Wilkins heard a declaratory judgment along with a direct appeal from a classification hearing, right?
Right.
Do you say that's improper?
Well, the declaratory judgment process is different than the MJP process.
And they be brought together.
They may be brought together.
All right, so they were here.
Right, but during the declaratory judgment, the Attorney General's office has to be notified, and there's a whole discovery process that can be gone through.
Okay,
but in the end,
I guess my question is just this. Unless we conclude that it's immaterial, and we might, don't we have to remand it for all of that to happen so we can find out whether Doe has been classified a 3 using a factor that is unsupported and can't constitutionally be applied in his case?
No, I think in the end, the burden is on a future offender to bring that issue. This issue is closed because it wasn't proven at the Superior Court level.
No, this is on judgment on the pleadings. Nothing was proven. There was no trial.
Right.
There's no finding of fact, this is or isn't supported. So, the question isn't whether it's proven, is there enough there to defeat motion to dismiss?
Well, the board's position is no. At that time, the offender could have asked for a trial on that issue. They didn't. They wrote an MJP, included the unconstitutionality as an issue.
The declaratory judgment claim, which does ask for a trial by bringing the claim.
Right. But it never went to trial. Instead, they put the argument in their MJP.
Because the judge said we don't hear declaratory judgments like this.
Excuse me?
The judge said we don't hear declaratory judgments mixed with this. Bring a separate action. But if that's wrong, shouldn't there be a trial?
Again, I think that at that point, and I'm not sure that the offender's attorney registered an objection to that or filed the necessary action at that time or filed a petition with the court to reconsider that decision. I don't know that any of that happened. I don't believe it did. So there was some burden on, again, to go forward with that with the offender's, on the offender's side to go forward with that issue. It wasn't gone through as it should have at that time. That doesn't mean that this court now has to go back to rectify that. I think that, again, that issue could be raised in the future on future cases, but I think as in this case, where right now we're dealing with as applied, I think that the board has met its burden in this case going forward. And I think that, that under those circumstances, that it should be upheld at this point.
So let me just ask you, I think, in fact, we can agree that there are two mechanisms, both as applied and the overall constitutionality of a factor by the Sex Offender Registry Board. And it appears that your valuable opinion is that the declaratory judgment is actually a better vehicle for challenging the constitutionality to everyone about a factor that may or may not have scientific backing and support. In this instance, it looks like the Superior Court judge found that the Doe didn't provide enough evidence to meet the threshold burden of establishing to go forward on declaratory judgment. So when we look at, am I correct in hearing you? Okay. So when we look at as applied, I hear one of your arguments to be, because as applied may be the argument of there was no confrontation, and then it's a factual determination as to whether factor 2 really can be considered. Was there substantial reliable evidence, right? You make another argument that says, let's take away that portion of confrontation. There's still enough evidence from which the hearing examiner's decision could be affirmed that Doe is a level 3.
Correct. And that's based on a later version of Doe 22188, which says that if a factor is misapplied, obviously the next step is to decide whether or not whether or not the facts dictate the proper classification. In this case, it would be, do the facts without factor 2 dictate a level 3, which the board believes it does. If the answer to that is no, then you look at whether or not the misapplied factor may have possibly affected the decision. But it's the step in between where I'm arguing, one, it was applied properly. If you don't agree, then I'm saying that the remaining facts still dictate the level 3. And if you don't agree on that, then I'm just going to say that I don't think it really possibly affected the decision, which would be the board's 3-step argument on that matter.
Can I ask, the judge didn't really say there's not enough evidence here for declaratory judgment. I read the opinion last night, and what the judge said is, I will not hear a declaratory judgment paired with a direct appeal from a classification. It should be brought as a separate action. Do you agree that Doe can still bring a separate action for declaratory judgment?
Yes.
And would the classification be stayed pending that lawsuit?
No.
Is it stayed now?
No.
Oh, so it's not stayed even pending appeal?
No, because you have to get the Superior Court to grant that stay.
Oh, I see. Okay, yeah, no, I get it.
Right.
Okay.
Unless there's further questions, I'm willing to rest on my brief.
Well, we always have more questions. And we thank you both very much for answering all of them. It's very, very helpful for our understanding of the issues, and we appreciate it.
Thank
so
you.
we'll take the case under advisement. I know that the students have other things to do, and so they're going to be leaving now, and that's fine. Thank you very much. I hope you enjoyed your time here. While they're leaving, I'm going to call case number 3 to come up, which is Henry KOMOSA versus the Board of Assessors of the Town of Montague, 2023-0454.
Good morning. May it please the court. My name is Mark Dickinson. I represent the appellant, Henry KOMOSA. So the Appellate Tax Board got this case wrong, and it basically ignored the plain language of 61A Section 3, and more importantly, it really ignored its own precedent. And if you look, it's buried in our addendum, but when the Appellate Tax Board in 1985 determined the Gosnold case, which ultimately went up to the SJC, it cited a New Jersey case that I believe is really close to this case in the sense that, and it cited with approval, this was before 61A had been litigated before the SJC, and the Appellate Tax Board said, quote, the Supreme Judicial Court has not passed on the application of 61A. However, a New Jersey court has held that land which is in fact dominantly devoted and dedicated to agriculture and not some other alien principal use, which meets the 5-acre and gross sales requirements to qualify as land actively devoted to agriculture, is entitled to assessment as farmland, even if a portion of it is only being actively farmed during the relevant period, and even if that taxpayer is going to be holding the land for eventual resale or speculation. That case is
Isn't the word devotion the key thing there?
actively devoted, yes.
Yeah, actively devoted. That would mean the entire 5 acres would
No,
be actively devoted. I
that-
mean, whether or not a portion of it is being used, and we'll use the example of growing hay because that's what we have here, right? Why doesn't that, what you just read to us?
Right.
And you use the term, that the term is being used as devotion, devoted to.
Actively devoted, right.
Actively devoted, right? It doesn't say a portion actively devoted. The 5 acres needs to be actively devoted, which means that not every single square inch of 5 acres has to have hay on it, but the entire parcel has to be devoted to it.
Well,
Right?
There's really no dispute that the entire parcel is devoted to.
We're
other
not
words-
bound by what they said in some prior case anyway.
That's right. That's true. You're
So
not bound by it.
we need to figure it out.
I think
And even if I agree with you that there's now 2 different cases going 2 different ways there, we still need to figure out which is right, don't we?
That's absolutely true. But I think it's very helpful and persuasive to look at that New Jersey case. But, Your Honor, to get to the question at issue here, we disagree. We believe that the way the statute works is thus, that you just need 5 acres of land, which
Okay.
we have. We're exceeding the 5 acres requirement.
5.6, whatever you have,
Right.
yeah.
And let's assume the facts that the town found, which was that only roughly 3.1 were actively productive. There's really no dispute that the remaining land is commercial or it's really what it is, I think, best classified as this New Jersey court classified as it's marginal land. It's not.
Right.
It's not
It's
cultivated
slopes
land.
and this and that, and.
It's got
Right.
slopes and trees. The gist of it was the findings below that, we probably, we're doing the substantial evidence test here, so we got to give great deference to what the ATB found. But the point is that they didn't find that Mr. KOMOSA was operating a gas station or
Correct.
some other, he was cultivating or excavating rather, as we see in the Henry case.
And your point is that some contrary use would be necessary, evidence of some contrary use in order to defeat
Yeah,
the application of Section 61.
What I want to adhere to as closely as the facts in this case, which is
Yeah.
the non-productive land that we're talking about are trees and some roadways or pathways, and just because the land is, not cultivated, and just because it's not actually productive, that doesn't mean that under the statutory scheme here, it means it's qualifies as the 5 acres.
Then why do they have a rule about accessory use? It doesn't have to be an accessory use to count toward the 5 acres, according to you.
Right.
So why would you have a category that says, oh, also accessory use land counts?
Accessory use land, incidental use, it's basically to show that, you don't.
You don't need it, according to you.
Yeah, well,
That's surplusage in the statute now,
Well,
right?
I'm not going that far. I mean, maybe it's not surplusage in the statute. It's to try to make sure that for farming operations where you have, let's say, areas where I think it's the Sliski's case, where you have piles of logs and they're non-productive, so nothing can grow on a pile of logs, yet you need a place when you're cultivating timber to put the logs, right? So that covers.
But according to you, if the logs weren't there, it would also be included.
It should be because it's the
You're saying because it
purpose-
can't be used for anything else.
It can't be used for anything else.
But that's not what the statute says.
Well, the statute, the intent of this legislation is to promote open space, promote agriculture, promote horticulture, and just because you're not actively using all 5 acres doesn't disqualify it.
All right, so
And
I go to the
back-
Cape,
Yeah.
and I'm the luckiest guy in the world. I can't believe that there are these 6 empty acres in Harwich.
Right,
This is the greatest day of my life, and a guy is willing to sell them to me.
right,
And the guy sells them to me, it's 6 acres in Harwich, so it costs me $20 million.
right,
I buy it, but there's nothing on it, it's vacant.
right.
I figure I'll hold on to it for a few years, watch it go up and up and up, and then subdivide it.
Right,
But in the meantime, I plant some wheat on one of the acres.
right,
But the thing is 6 acres big.
right.
And now the town says, well, we'd like to tax you on this. It's worth $20 million. And I say, oh, I'm sorry. The wheat I grow here, I make $500 a year from that.
Right.
So the whole 6 acres has to be taxed at the lower rate.
Correct.
And that's a correct argument, you're saying.
I think that's perfectly logical. First of all, it's commanded by the statute. Section 3 says, the question here is, are more than 5 acres actively devoted? And we look to Section 3, which says that actively devoted land shall be deemed if it produces X amount of dollars of agricultural goods that can be sold. And that's all you have to look at. And that furthers the intent of the statute because, first of all, the land here, and coming back to our situation, are just trees and badly sloped land.
I'm asking about my hypothetical. It's 6 acres in Harwich.
The 6
And
acres-
I'm guessing you can grow wheat as of right, maybe everywhere in the Commonwealth, but
Right.
probably in Harwich.
Well, again, the legislation was to promote relief for farmers. And so you don't, and part of the rationale in this New Jersey case I was citing is that we don't want to have, if there's marginal land or the other 5 acres, you have a farmer who's has to put extra efforts in cultivating this marginal land, that's not conducive to, it's going to make things harder for the farmer, it's going to make things more difficult to achieve the societal benefits of having open space. And I think in your hypothetical, we're promoting agricultural uses and horticultural uses, the town gets a benefit of open land,
Of the 1 acre of wheat.
even though it has the 1 acre.
Sounds like a huge benefit.
I'm gonna
If we
interrupt
tell
you.
developers and towns this is what we're reading,
Well, I don't think it's a
Now,
windfall.
I think we can say that Harwich is not the same as Western Massachusetts.
True,
right.
true.
well, I
Just-
think we can say they're both covered by the same statute.
We
though.
can say that.
They are covered by the same, but I think there's inherent fairness there. And you get into these difficulties of enforcement as well. Like what literally happened in this case is you have a dispute about whether this non-productive land under trees is shaded. And so why do we want to have assessors in Harwich or in Montague, making these fact-intensive judgment calls?
Sometimes assessors go into houses and measure how many square feet are inside.
That is true. But, again, we're getting away from what was the reason for this legislation.
But to that point, it's not clear. What if there's no hay at all on this piece of property?
Right.
I mean, not that I would imply whatsoever that there was anything nefarious going on here, clearly,
Right.
but somebody could do that. They could buy these expensive acres, to Justice Rubin's hypothetical, in Harwich, and then not grow anything and still not let anybody on their land or whatever. So clearly the assessor has to go on the land.
Right.
And here, of course, if you read the testimony of the assessor, there's a real effort here to figure out what's going on and why, et cetera,
Well,
right? But so what do we do with that? So the assessor says 3.1, I thought it was actually 3.6, but
3.6, I made
okay,
that.
okay. 3.6 acres are devoted, are hay. The rest of it is not incidental. It's not really the rest of the property is not devoted. Can't get to that amount. And the commissioner, that the board says, agrees with that, adopts those facts. what is your point? What can you tell us how we should approach that?
Well, I think this is the point, it's a very difficult position because the board is saying Mr. KOMOSA didn't meet his burden that the 1.4 acres was productive and active. But frankly, that's an impossible burden when you have land that's sloped. It's marginal. I keep using that word because that's the word that New Jersey court used. But it's not called. So the policy here is, so are we going to force, so Mr. KOMOSA now, if he wants to make sure that all of his 5 acres are productive, he's supposed to go out, work extra hard to maybe take down all those trees in the shaded areas, try to figure out to jury rig his tractor so he can go on a sloped plain and hay there. That's something.
Or maybe his parcel just doesn't qualify. I mean, lots of parcels will be 20 acres and be no trick to show that 5 of them are used, right?
That's true. But, you know, the actively devoted definition that we're given in section 2.
Can we get back to that definition? Because I'm having a little difficulty with your construction.
Okay.
That under section 3, right?
Correct, yeah.
So under section 3, you're saying that as long as the $500 rings up in the register,
Right.
then that means actively devoted.
Yeah, I mean, this is
And what
sorry.
I would suggest to you, that to me seems to be a stretch in the sense that section 3 says, land not less than 5 acres, an area shall be deemed to be actively devoted, we can fill in horticultural, for uses when the gross sales products resulting from such uses together with the amount under soil conservation is not less than $500. Tell me why I'm wrong in interpreting that to mean when you use all 5 acres and that amounts to at least $500, then we have met the definition of the statute. You're using that 5 acres, and that 5 acres is grossing at least $500 in profits, then you've met the requirements.
Again, I think that when you go back to the actual language of the statute, you know, it declares in that first sentence, land not less than 5 acres shall be deemed, that's the wording, shall be deemed actively devoted when the gross sales of the horticultural
Of the
product.
land not less than 5 acres, right? Not a portion of the land of less than 5 acres. When that 5 acres, minimum of 5 acres, that's the difference in the interpretation. So you're saying, as long as it take an inch of that plot, and I come up with these rare mushrooms, right? And there, I get $1,000. That means if I were to interpret the language here, then this qualifies. Because a little plot this big, grossed, but if you read it in conjunction, land not less than 5 acres.
Yeah,
Right?
I hear what,
Gross is 500. So land not less than 5 acres, gross is 500, then it's active use. Because if you had 5 acres and it only made 50 cents, that's not good enough for a tax abatement.
I understand your point.
Okay.
We read it completely differently, and no, maybe not completely differently, but we say that this is what is intended, a simple test where you have 5 acres, you have a gross amount that's created, and
5 acres that comes up with at least $500.
that's right. And the appellate tax board in the cases it cites in this decision, including the case, the Gosnold case, and including this, I think it's the Slisky case, they admit that you don't have to have every square foot actively producing every blade of grass, every tree for those 5 acres. And I think that's required by the statute, which is that I think the magic mushroom hypothetical is in play. And I think
But
that
would you agree that the magic mushroom hypothetical, even the hypothetical of the land of Harwich, does not really result in a furtherance of the intent of the statute, does it?
Well, I think it does, because
Because you're not helping farmers or, open land, yes, but you're not really doing anything about what.
You're allowing farmers to not have.
Well,
to
these aren't even
try to-
farmers here, right?
Right, well, that's.
Your
that's
client,
true.
of course, is mowing hay. I'm not,
Right, he's a man of many talents, he's a Renaissance man, and
Yeah.
one of the things he does is hay.
Yeah.
But he should get the benefit of this, where he has he has the 5 acres, he has marginal the slope,
Okay.
he should be able to
well, I
get
think we have your point. Well argued and well briefed, and thank you for answering all of our questions, including hypotheticals. Your time is over, so we're going to hear from
Thank you.
your sister here, who also provided us with a very helpful brief.
Good morning, Your Honors. May it please the Court, my name is Ellen Hutchinson, and I represent the Montague Board of Assessors. At the case at the Appellate Tax Board, Mr. KOMOSA had 2 things he had to prove, 2 things he had to do. One is he had to establish the requirements for 61A classification as they are found in the statute. Secondly, he had to prove to the Appellate Tax Board with persuasive and credible evidence that he met all of those requirements. The Appellate Tax Board, in our opinion, correctly ruled that he met neither one of those obligations. Your Honors, the requirements for 61A classification are found in 61A Section 4, and that, again, it talks about, again, the not less than 5 acres must be actively devoted to agricultural or horticultural use. Then there's another requirement regarding it has to be for the tax year in question plus the 2 previous tax years, which we conceded that was met. Right. That part of it was met. But the language of Section 4 requires the applicant to go deeper, because there's this notion of, as this panel has talked about, this idea of what is meant by actively devoted to horticultural use. And therefore, you have to move from Section 4 to Section 3, and that critical language, actively devoted to agricultural or horticultural use, is defined within that statute, as my brother referenced. And that says that land not less than 5 acres shall be deemed to be actively devoted to agricultural or horticultural use when the gross sales resulting from such use are not less than $500. But we think that this is the stage that the appellant misstepped. He stops his analysis here, because it's not enough that you're talking about actively devoted to horticultural use. You have to then know what your horticultural use is that's allowed. How do you know what the allowed horticultural use is? You have to go to the next statute, or the next provision in the statute, which is Section 2. So Section 2 says, yes, the haying was an allowable use, but Section 2 also says that that's not sufficient. Section 2 says for land to be in horticultural use, it must be primarily and directly used, in this case for the growing of hay, or alternatively, it must be primarily and directly used in a related manner which represents a customary and necessary use in raising the hay and preparing it for.
What manner? What's the word before manner?
Customary.
Customary and necessary.
No, before that. It must be used
In a related manner.
related manner.
Yes, I'm sorry. When primarily, Your Honor, when primarily and directly used in a related manner, which is incidental to those uses and represents a customary and necessary use in raising these products and preparing them for market. Mr. KOMOSA admitted that all of his land was not used for haying. He attempted to, I think, try to establish this second part, this primarily and directly. He argued that his land was used for an access road. He argued that it was used for what he called bad hay composting and for brush piles. But, Your Honor, if you read the transcript, if you look at the evidence, Mr. KOMOSA's attempts to meet his burden of proof by suggesting that these are primarily and directly incidental or customary and necessary uses fell short, because he believed that his only requirement was found in Section 3, actively devoted $500 in gross sales, and that was it.
I disagree with that.
You do?
I do, because there is a memorandum, it's Exhibit 1, and in it, Mr. KOMOSA describes these things that go on in the part that isn't growing hay. That's the only evidence in the record about what goes on in the part that isn't growing hay. Now, maybe you're saying the judge is entitled to simply find Mr. KOMOSA incredible, but it sounds like you're saying as a matter of law, what he describes isn't an incidental use. And I don't know, I'm not sure, not incidental, a related use that's customary and so on. I don't know much about growing hay, but I don't see, it sounds like it is. It sounds like having a road might be incidental to getting the hay out of the property, right? It sounds like he says he dries it on, in some cases, the riverbank, or composts or burns leftover hay. I don't know, as a matter of course, what people do who grow hay who have wet or leftover hay, but it wouldn't shock me to find that they did something with it on their land. And your expert said nothing about what was going on there. Your expert said only, and I think the judge makes a clear error about this, your expert said only it can't be used for growing hay. Okay, but he's not saying it's used for growing hay. He says it's used for these incidental purposes.
Most respectfully, Your Honor, I think what the chairman was saying at the Appellate Tax Board was that Mr. KOMOSA never established that the road, the bad hay compost, and the brush piles were, in fact, customary and necessary uses incidental to the growing of hay. We're not suggesting as a matter of law they're not. We're simply saying that the Appellate Tax Board found that his evidence was lacking, that he failed to make the necessary...
So next year, we're going to have this case again, spend thousands of dollars on lawyers, or tens of thousands maybe by now, and next year he's going to also bring in a pamphlet that says, when growing hay, you might want to compost the wet hay. And now he wins. He did say he was composting it. But I'm not sure why that's not adequate. There is no evidence that it's not being used for the things he describes. Right?
I would agree with that. But again, Your Honor, with all due respect, I think he failed to present both a quality and a quantity of evidence to suggest that these types of additional uses are customary and necessary. There was nothing, I believe, in the record...
You're saying, excuse me for interrupting you, because you're saying that his testimony is insufficient.
Is insufficient.
Right, even though he's been doing this work in terms of maintaining this hayfield and for a number of years.
Yes, because...
I mean, in other words, he knows what seems not that easy, I would imagine, to get your tractors out there and know when to mow and how to bale and get it to the farmers down the road for their goats, et cetera. So there's some know-how here.
I would agree with you, Your Honor, that there is a know-how there. But again, I think part of the problem was Mr. KOMOSA didn't think he had to present evidence on that.
But he did, though, right through his own testimony. I guess what I'm struggling with is that what case or theory would support your interpretation that the landowner's testimony in and of itself, when there's nothing else to refute that, isn't sufficient to meet his burden?
Because I think when you look, Your Honor, at the transcript, if you look at the evidence that was presented, there is nothing there which makes the connection that these types of uses, the access road, the bad...
He didn't go through, excuse me for interrupting, but he didn't go through A through B, now then I compost, and the reason I compost is because I have wet hay and then wet hay. He says it. And he leaves out some explanatory details of the running of a field or a plot of land for purposes of growing hay. Sure, he doesn't detail every single way in which, from seed to stock, hay is then harvested, but he does say it. and there's nothing else to refute it. And so just as a matter of legal principle, why do we dismiss that as saying, it's just your opinion and you didn't give enough detail for it to be properly weighed? I'm struggling with that.
I think, Your Honor, first because of the small size of the property. You're talking about 5.641 acres, so there wasn't a big margin of error. And again, if you...
See, it doesn't matter to me. If he had 1,000 acres, it's his testimony that some of the land I used for brush, some of it I used for composting, some of it for a road. Why is that not enough?
Because there, Your Honor, most respectfully, I think that there's nothing in what the witness testified to establish that those additional uses, the bad hay composting and the brush piles, were customary and necessary uses for the purposes of growing the hay or for trying to bring the hay to the market. And I think that that's where his evidence was lacking.
Hypothetically, not to put you on the spot, but hypothetically, because it was obvious here during the hearing that everyone's trying to struggle with the right way to interpret this statute.
Absolutely.
A pleasure to read that. But hypothetically, let's say Mr. KOMOSA said, along the lines of both my colleagues have brought up, when you mow hay, you have to have an area to compost. So for years I've done X. When you mow hay, I have to have an access road because the tractor is 12 feet wide in the back, and I can't just use a path. I have to have and I've been doing that for so many years, period. And by the way, I've gone to school a couple of times let's pick a place in Vermont where I've learned about special techniques, et cetera, and I've learned that these brush piles are really important. Had that happened, or are you saying that still wouldn't be enough? There had to be an expert or somebody else to talk about the operation of mowing the hay. Would it have been okay if that kind of information, more specific information, had been provided by Mr. KOMOSA here?
Your Honor, I'm reluctant to speak on behalf of the Appellate Tax Board, but in my opinion...
I understand.
In my opinion, yes, I think it would have been sufficient.
Okay.
So here's what
I'm only asking you hypothetically, so thank you.
No, I understand.
Here's what the judge says. He had the burden of proving that portions not dedicating had some reasonable relationship to the primary use, some customary and necessary use in raising such products and preparing them for market. The appellant failed to meet this burden. Moreover, the board found credible the testimony and documentary evidence, in particular aerial maps and the personal observations of Assessor Tonelli, offered by the assessors, showing that substantial portions of the parcels at issue did not support the appellant's haying operation. Instead, they were under the shade of trees or on banks where no growing or harvesting of hay or any related activity could be performed. But the expert did not say no related activity could be performed. All the expert said was, you can't grow hay there.
Your Honor, most respectfully, the witness was the assessor, and she was not given expert witness status. She's simply the assessor.
But she didn't even say this.
No, I agree with you. She did not say that. She went out and, again, and did what is asked of her. She went out...
I'm not upset with her. I'm saying that the commissioner said that call her an expert or not, the assessor's statements included that you couldn't do related activity there, and I don't think the assessor said that. I'm not saying the assessor did anything wrong. The assessor, I agree with you, did exactly what, if you're right about the 5 acres, what they're supposed to do, which is see how much of this land is used for growing hay. But the accessory use part, I don't know how an assessor would figure that out, except maybe talk to the owner.
I agree with you. I think that, again, if the witness had gone that next step, as Your Honor had set forth, frankly, in your
hypothetical,
hypothetical, thank you,
It's okay.
that, in my opinion, again, not speaking on behalf of the Appellate Tax Board, but speaking on my behalf, that I think it probably would have changed things legally from the assessor's perspective. Understanding that the law requires that it's either primarily and directly used in the growing of hay, or it is primarily and directly used in incidental and customary and necessary uses. If he had presented sufficient evidence to establish that those other uses, the access road and the bad hay compost and the brush piles, were customary and necessary uses that were incidental, I do think that it would have been a different story. I think what the Appellate Tax Board said was there wasn't sufficient evidence presented by the appellant sufficient for the Appellate Tax Board to reach that conclusion.
I have one more question on my hypothetical, and your time is almost up, but let's say that Mr. KOMOSA did testify in that manner, but all of that only happens on 1 acre. The brush, all the things that I need, the whole 5 acres are not used for that. It happens on it happens on 3.6 acres, because the other 1.4, there's no way anybody can do anything with them, period. Then you're saying in that case, he would not have met his burden.
It would not have met his burden of proof.
Because your view still is that the full 5 acres have to be devoted to either primarily the haying or incidental. So if you happen to have a huge steep ravine or a mountain on your property, it might be nice for a view, but that means you're not going to get the benefit of the tax break, because you're only at 3.6 acres, period, or 4.9, or whatever it might be.
There are other avenues for taxpayers to attain tax breaks, but under this 161A for the classification horticultural, I would agree with you that they would not qualify.
Okay. Any more questions? Thank you both very much.
Interesting case, certainly.
Very interesting case, yes. Thank you both very much for your arguments and answering all of our questions. We very much appreciate it. So we're going to hear one more case before we take our morning break, all right? And that's Elizabeth Marino versus City of Newton, 2023-1044. Good morning.
Good morning, Your Honor. May it please the Court, my name is Krishna Basu, and I represent the City of Newton in this case. The issue in this case is whether the City of Newton is immune from suit under the discretionary function exemption of the Mass Torts Claims Act. And the courts have consistently used a two-part test to determine whether the discretionary function exemption applies. The first test is whether the actor had any discretion as to what to do, whether they should have done what the plaintiff says claims the harm. And that's not disputed at all in this case. Both the trial court and the plaintiff's counsel agree that there was no statute, regulation, or established agency practice here that governed what the City of Newton should do. The second part of the test is it the kind of discretion that Section 10B provides immunity for? And what the courts have looked at is, does the decision or does the function by the city or town involve planning, policy making, weighing alternatives and making choices, or the allocation of resources, as opposed to carrying out previously established policies or plans. So the issue before the court is the claim made by the plaintiff here a discretionary function or duty? And so what we need to do is look at what is the plaintiff claiming that the City of Newton did do or didn't do that caused her injuries. And what she alleges is that the City of Newton allowed a dangerous condition to exist in the parking lot. And what that was ice. And the plaintiff claims that the City of Newton should have salted either more frequently in the parking lot or earlier in the day in the parking lot. And the case law is clear that decisions that involve allocations of limited resources, which is what occurred in this case, planning based on weather, personnel, equipment, is a discretionary function. And we know from the record appendixes in the record that the City of Newton can't possibly salt every surface of the public property that's under its ownership constantly. And so decisions have to be made because there's 320 miles of roadways, 79 miles of sidewalks, 15 parking lots. And so the city needs to make decisions. And also in the snow plan, which is in the appendix, the city talks about how the DPW department will consult with the mayor, with the police, with the school department, and look at the severity of a given storm and what is going to be prioritized. The other thing that is mentioned in the snow plan is that there's 6 operational readiness conditions. So some storms may need, up to 12 or more snow trucks or salt trucks to take care of the snow and ice during that storm. Others may just need 1 where there's no immediate need, and it's someone that will be on call. And those decisions involve fiscal considerations, policy decisions that need to be made by the city in those cases as to what is necessary. And I think that the case that provides guidance for this scenario is the Barnett versus City of Lynn case. And in that case, children were sledding downstairs and were injured, and the plaintiffs claimed that the city of Lynn should have removed the snow from those stairs. And what the city of Lynn discussed in that case was that they had fiscal constraints on the city. The city couldn't possibly remove snow from all of the public property in the city and had to make decisions. And they decided to prioritize things like the schools.
But aren't there fiscal constraints on literally everything? Everyone does, but certainly a city or town does. Yet in Doherty, they found that maintaining a parking lot, which has fiscal implications, it costs more to do it one way than do it another way, that was not entitled to immunity. How do you square that?
Well, I think, Your Honor, the Doherty case does provide guidance as to what would be a discretionary decision and what would not. And in the Doherty case, the court held that the decision to take down the parking meter poles was something that was a planning, was a policy, was a discretionary decision. But once that decision was made, when the employees were then told that they needed to pound those down into the pavement, that was not a discretionary decision. That was more of a ministerial decision.
Costs money.
Well,
They're going to stay there longer. I don't know how you pound a metal thing into the ground. I never thought of doing that, but it must, right? You have to have the people stay there longer. Maybe they need some other piece of equipment to do it with. It costs money.
Well, the court held that that was just the carrying out of a decision, and so that was not an issue.
But it was a
in that
decision.
case.
It was a decision. We'll carry it out this way, not that way.
It's correct, but the court found that carrying out of a decision was not something, because as Your Honor suggested, I mean, every decision has some discretion, has some considerations.
Sure, like did we plow this place or salt it negligently or not?
Correct.
Okay, but that's this case.
But
Did they salt it negligently or not?
Well, no, because the allegations in this case are, should it have been salted more regularly? Should it have been salted more often?
But they decided not to. The method they chose to use to clear the snow and keep it safe, once the city decided to keep it open. I mean, I don't know where the line is. I don't understand. I mean, it becomes a gestalt thing, right? What's maintenance versus what's deciding to do maintenance or whatever. But I just find it very hard to, I mean, you're getting down to very, very nitty-gritty questions. What is the not immune decision? Which salt to use? Which driver will, I mean, I'm trying to figure out where there's anything in, it seems like you're almost all the way at the bottom of this, and it's still constantly discretionary.
Yeah,
so where is the line?
Your Honor, yeah, I agree that the line is not as clear as maybe suggested in the Barnett case, that once the city removes the snow, that's the end of the issue. I think we can gain some guidance from the Ginsburg case, which is a non-published case, but it's a case that I think more goes to sort of the degrees. And what the court was looking at, that's the case where the issue was that the city had not repaired and replaced the lights, the street lights. And the city offered that there were fiscal constraints, and so that they could not do the streetlights as quickly as the plaintiff was alleging. And I think that that is, provides some guidance, because here we have the same types of things. We have fiscal constraints on how many trucks can be, would be set up for a given storm. Whether it's a type of storm that's an emergency, they have to have all hands on deck, that we have to have police, that we have to have DPW working 24/7.
But so that's not a fiscal decision at all. That's a decision of what is necessary to do, and you could do that negligently or not negligently. What do you mean? It's a major blizzard and you use 2 trucks? Right? Do you see what I mean? Like, I don't see how the internal thought process can matter either. Maybe they didn't bang down the things because they didn't have enough money to keep or enough people to keep the people there to do every parking meter or whatever. Or maybe they didn't bang it down because the guy in charge of it can't stand the noise from the sledgehammers. Or you know what I mean? We don't know.
Well, Your Honor, but that wouldn't involve a planning or policy decision to the same degree. I agree that it is a matter of degree, and that what we can gain is that we know that the decision to remove snow, that's a discretionary function. And we know that the decision about whether or not to remove the parking meters was a discretionary function. But carrying out, once the decision was made to remove them, the ministerial act of just pounding them into the pavement was not a discretionary function. And I would
For
submit.
example, not to interrupt you, back to the Ginsburg case, your point would be that in that case, the decision whether or not to get to that particular street lamp, because they only had one bucket, one truck to do it, and only 2 people who could, and instead of the usual period of time of, I think it was 2 or 4 weeks, it took a couple months, that's okay. But while they were actually doing the work, if they did it negligently, so like fell down on somebody, that would be different.
That's correct, Your Honor. That's correct. And so I think we can also see some of those questions and whether the degree is by looking at the Stoller case. I mean, in the Stoller case, the court held that certain functions of a fire department, like the number and location of hydrants, the number of location of fire stations, what property to save in a fire, all of those were discretionary functions. But the issue that was in that case, the alleged negligence, what the court looked at is, what is the plaintiff's theory of the case? And in that case, it was the failure to use the sprinklers. And yes, there was some discretion in that, but it was not the type of discretion that provides immunity to the city in that case, because it did not involve policy and planning considerations. I'd like to just turn briefly to the other argument that the plaintiff makes, which is the duty to warn. And I would suggest
Is that properly before us?
Well, the lower court did not. It was part of the city's
Doesn't
summary
matter.
judgment, but the lower court
You're
did.
here under the doctrine of present execution, right?
Yes.
It's an interlocutory appeal, so I think all we're allowed to hear is the part that raises a present execution issue. Do you have any, I mean, you may not have thought about that, so.
Yes, no, I hadn't thought of that, Your Honor, but the lower court didn't. It was part of the original case. It's not a new argument by the
No,
city,
I'm not
but
saying
it
it
is
wasn't
not
raised.
covered
I'm
by.
just saying if that were all you had, you wouldn't have gotten, that's not something
That's
that you
correct.
can bring an interlocutory.
That's correct.
Okay.
It wouldn't be the subject of an
I
interlocutory
mean, you can
appeal.
argue it, of course.
But the record is clear that it's undisputed that there was snow and ice on the ground. We have the plaintiff's testimony in her deposition. We have the photographs. And the courts have held that there's no duty to warn. And I would say that this argument is just limited to the duty to warn, not to make it safe, to notify people that snow and ice could be slippery. And so I would like to just also suggest to the court that there are very important policy reasons that the discretionary function exemption should apply to this case. decisions about snow and ice removal involve important economic and policy considerations for all of the cities and towns in the Commonwealth, and the cities and towns need to be able to make judgments and plan and make those decisions based on the resources that they have. And the discretionary function exemption is, the intent is to not allow certain types of decisions like this to be second-guessed by the courts, because it could create a tremendous burden on cities and towns were that to be the case. And so the negligence alleged here, how early and how often the snow and ice was removed and treated in this parking lot, is something that the city should be immune from liability on, and summary judgment should be granted.
Thank you very much.
Good morning, members of the panel. May it please the court. Michael Vasilla for the plaintiff, Elizabeth Marino. I think the city of Newton is trying to stretch the discretionary immunity function a little too far and say that under no circumstances are they ever going to be liable for any situation to do with snow and ice removal. The discretionary decision that the city of Newton made in this case was to keep that parking lot open. This is a public parking lot that people paid to use. Once they left it open on a snowy day, they agreed that they were going to clear it. Once they did that, the discretionary function was removed, and this is now a maintenance case. They had to maintain the parking lot in a reasonable manner to make it reasonably safe for people to come and go. The Barnett case is very instructive, I think, because it specifically distinguishes this situation. In Barnett, the city hadn't done anything with regard to snow and ice removal, and they said that that was for this public park and staircase. And the court said, that's okay, that's a discretionary decision, but they specifically mentioned that had they decided to remove snow, they would have had to do so in a non-negligent manner and could be found liable for issues that arose because they had chosen to remove the snow. Once the city of Newton chose to remove the snow for the parking lot, make it open to the public, they had a duty to make it safe. And they had a duty to make it safe from when they started charging, when it was open. If they were going to say this was a discretionary decision, that we're not going to get to that parking lot till later, they have methods of notifying the public of this, making it known that parking lots are our final priority. We're going to make sure the kids can get to school. And I understand that's got to be a top priority. Kids can get to school. But people getting to work and using public parking lots is also a priority. But if the kids getting to school was the priority, they need to then make it clear that the parking lot is open for use, but we're not going to be able to clear that until later in the day. You're kind of on your own risk if you're going to use it. And by the way, I don't think we should charge you if you're coming to a parking lot that hasn't been cleaned or taken care of properly. I think to Judge Rubin's question, that's where the line was. When they decided to open the parking lot and leave it open on the snowy day, they had the duty to make it safe for people who to use it, just like any other owner of a parking lot who was offering it for services. The metal stumps case, I think, the Doherty case is very similar. They had sent them out there to remove the stumps. They didn't do it properly. And in this case, the city of Newton sent them out there to remove the snow and ice, and they didn't do it properly. Somebody got hurt because of it. The Q claims, I think the city of Newton just tries to micromanage where the decision is, and we need to put it higher. Once the parking lot was available for use, then it needed to be safe for people to use it. With regard to the open and obvious, I cite the Soderberg case, which says that open and obvious doesn't apply to unnatural accumulations of snow and ice. I do agree with Justice Rubin's interpretation that perhaps we shouldn't even be discussing that, but I just want to mention it because it was mentioned in the reply brief. Unless the court has any questions.
What if the city had a policy that said, and that was published, when it snows so much, so many inches per minute, or et cetera, we're going to do X, Y, and Z, and public parking lots will be cleared only once every hour. That's it. Would that change the scenario?
I think that does change the scenario, Your Honor. It notifies the public, puts them on notice, and the public parking lots are still once every hour. We don't really know here when it was done. It was done either before or after my client fell. We're uncertain, but the last time it had done before that was a full day before, even though it had gotten cold that night.
Okay. Questions? I see no more questions, so thank you very much for presenting that issue to us. We'll take the case under advisement, and we're going to take our morning recess now as well. Thank you.
Testing 1, 2. Check 1, 2.
No, because their mic is off. Your mic is off, right?
Check 1, 2.
The audio is way up. It's really high.
Yeah, I can't control it.
We just have to use the.
You just use your mics. Okay.
You have to turn that one, that loud mic on, please. Of course, I guess that, yeah. This is all. You're good? Yes.
court is now open. Please be seated.
Thank you. All right. Yes, we're exactly in the afternoon. So good afternoon. I'm going to call the next case, which is MTGLQ Investors versus John McGillen. Did I pronounce that correctly? McGillen?
Yes.
Correct? Okay. And it's 2023-0800. There was a motion that was filed requesting rebuttal in this case, and we do not have rebuttal in the appeals court. So you present your argument, and during the course of your argument, we'll ask you questions, and we will have in our minds, of course, what the other side has already filed in their brief, and so should you in terms of how you present your argument. All right? So the appellant here is you. All right. And you are Ms. McGillen, is that correct?
Abigail Font.
Abigail, okay, all right. Yep.
Sorry. Good morning, panel of justices. My name is Abigail Fopp on behalf of McGillen, John and Amy and the other McGillens, pro se. I'm here today to attempt to litigate in an appeal versus MTGLQ versus McGillen in the case for 666 Main Street, Harwich, Massachusetts, due to the lower court in Southeast District that I believe that the trial was done improperly and some things were overlooked. I do believe that evidence, video, and testimony that was submitted was ignored or was not taken into correct account.
Can I interrupt you for a moment?
Absolutely.
Okay.
Sorry, I'm very nervous.
No, no.
That's why you're doing fine. We asked lots of questions.
I want to say that we all have looked at all of the documents that everyone has submitted in the transcripts, and I give you a lot of credit. And so what I'm trying to do is just make sure that I'm clear in understanding your argument. So if you don't understand what I'm asking, please ask me. And,
Okay.
and it's only meant to get to the right result, okay? So for both sides. So I want to make sure when I read, it's entitled your reply brief, but it really focuses, I think, on what you want us to look at in the appeal. And issue number 1 and 3 really had to do with allegations that you make that really boil down to improper bidding process during the foreclosure, which would invalidate the foreclosure in the superior title, correct?
Correct.
Okay. And then the second issue, so that's 1 and 3, they're a little bit different, but they're really, to me, and again, number 3 includes the fact that the judge ignored the thumb drive, because that has to do with the auction.
Yes.
Okay? So issue 1 and 3, auction, its improprieties, and the judge's error in not considering that thumb drive. The next issue that I see, again, is that there was a discrepancy with the recording. The 30-day limit was not honored, and with strict compliance, that means they don't have superior title to possession. And then the fourth issue that I see is, I would generally call it a lack of professionalism and integrity with the justice that was responsible for conducting the trial. Do I have the legal issues that you want us to kind of untangle? Are those, am I missing anything else?
No, Your Honor.
Okay. All right. So sorry to interrupt. That's
okay.
That's very, very helpful. Could I ask you to focus some of your time then on the issue of, I read the transcript and you testified in detail about outbid license plate and what went on and the video recordings and the police coming and the improprieties. That testimony, your statements to the judge, I read. But what I didn't see was, understanding your pro se, any attempt to comply with the rules of evidence and introduce the photographs. So I'm not saying that what you said under oath couldn't be considered properly by the judge, which is substantively, this whole auction was fraudulent. But what I didn't see was any proper procedure that you said, Judge, I'm asking you to introduce this thumb drive into evidence, and I've provided a copy for the other side. Did I miss something?
No, Your Honor.
Okay,
Sorry, I just feel like I'm going to pass out, so I'm a little shaky.
Water and we
Yeah,
can-
there's
Why don't you
water, right?
take a seat. Why don't you take a seat? Okay, take a seat. It's all right. You sit down. Nope,
No,
that's
no,
absolutely
of
fine.
course, it's,
It's fine.
I'm,
That's
sh-
okay.
it's,
That's all right.
we know how difficult it is for non-lawyers to come before judges. But you should take a glass of water. There's water in that pitcher, or you have your own water, okay?
I'm not just saying this. I think you're doing a terrific job, and lawyers have difficulty coming up and arguing. So just tell me, like, you didn't present the evidence in a way that a lawyer mostly would, but you think that the judge made a mistake.
Correct.
So tell me why.
So.
Well, why don't you stay, why don't you stay seated? That's absolutely fine. Oh, of course you can. Yeah, of course you can. And we'll just have you stay seated for this argument, all right? Okay? And you,
Can we move the microphone over so that
So,
it records?
yes, the docket entries number 16 and 17 that are still under review by the appeals court panel current, I do feel carry a lot of weight. They were submitted 3 times to Plymouth Housing Court, and Melissa Rooney put.
It's no,
I'm so sorry,
no.
that's my daughter.
She's,
That's okay.
it's fine. It's really fine.
yeah.
So sorry.
It's school vacation week. It's not a problem. All right. But that's all right. Yeah, but I'm wondering if
And
maybe
you have a
we
new
can.
water, too, which is
You
good.
should grab your water.
I'm wondering if we can move the microphone a little bit so that we
I'll
can.
speak up. I'll speak up.
No, no, but it's just over here. I want to make sure that we get, because it's being
I'm
recorded.
so sorry.
That's okay. All right.
So my father hand submitted it once.
Tell us about that. You say
Thumb drive.
you say on the record, in the transcript, my father submitted this.
Submitted the thumb drive.
Now, there wasn't a factual hearing about that, but do you know how or where or?
To Plymouth District Court, and I actually highlighted it in my brief and appendix in a docket entry dated 9/17 of 2021. It was submitted. It was also mailed in.
Wait, there's a docket entry?
Yes, there is, Your Honor.
All right, hold on, because I didn't see that, but I think that,
I do have a copy of it with
well,
me.
we have the docket right here, so
So
let me just.
just try to, I saw that. So when you, as a lawyer or non-lawyer, mail something to a court, it sounds harsh. Even if a clerk, an employee says, I got it, it's now docketed, it's in the file. When a trial occurs, formally, evidence needs to be introduced at that trial or hearing, right? So it may be in a file, and somebody in the clerk's office might have said, here's a receipt, and we're going to support that you gave us a thumb drive. That doesn't mean that it becomes an exhibit for a judge to weigh. I don't necessarily think that your case wins or loses because there aren't photographs of a Cadillac with outbid or whatever the brand is, because you testified about what happened, about observations. So I want to spend some time, but time is a really important thing here.
Okay.
I'm just, at the hearing, trial, there was no motion to introduce the thumb drive or the photographic pictures, exhibits into evidence, is what I understand, because you thought by mailing them and sending everybody copies in by a docket entry saying, we have a thumb drive that somebody mailed in, that that was sufficient.
Correct. So actually, Your Honor, it was not only mailed in, we were nervous about it being mailed in, so it was also hand-delivered. And clerk specialist Melissa Rooney did tell us that the judge would review it in his quarters
Right, so
previous to trial,
I'm not
or I would have filed a
questioning-
motion. I'm so sorry.
I'm not questioning
Okay.
whether you sent it. I'm assuming you hand-delivered it and someone said, I'm going to walk right back in, versus in order for a judge at a trial to consider the evidence, what is necessary.
Okay.
But again, you testified about the very evidence that those pictures showed.
Correct.
So the issue of the 30 days.
Yes.
Want to talk a little bit about that?
Please, I would love to. So this is the big discrepancy as well, which also pertains to docket entries 16 and 17, due to showing who won the initial bid on January 17th of 2020, that it was a local Cape Cod contractor, and it was not MTGLQ, and it was sold for $200,000. By Massachusetts strict compliance laws, it has to be recorded in the record of deeds, housing deeds and housing court within 28 to 30 days to be valid. If there were to be a backout or another auction, there's supposed to be a public proclamation and another auction that is held. That never occurred. The deed was finally dated August 11th of 2020 from MTGLQ. That puts it at 9 months prior, 9 months after. So that one does not meet the guidelines for the timeline per the laws. And also, they were not the original promissory note holders. So there should have been another public proclamation as well as another public auction held on the property of 666 Main Street for this to happen, for MTGLQ to acquire the promissory note and be able to properly record it, August 11th, 2020, in Barnstable Housing Court with the Registry of Deeds. And that also is why I like to go back and mention docket 16 and 17. So even if they do claim that they were the original winner, that does not fall within the 30-day Massachusetts strict compliance laws of needing to register it properly in housing court.
Okay.
And the judge put right in his rules and findings, right number 1, is that the plaintiff is the current owner of the premises via foreclosure deed dated August 11, 2020, and recorded September 2nd of 2020 in the Barnstable County Registry of Deeds at book 33226, page 55. So that right there does not meet the guidelines, which also shows he knows the auction was held January 17th of 2020 at 11:35 a.m. and closed at 11:35 and 47 seconds on that morning in question. So that right there, as a standing judicial officer of the court, he would know that that does not fall within the proper guidelines that Massachusetts strict compliance law entails. As well as, you know, I do believe that the pre-foreclosure standings were not done with proper due diligence in general. Chapter 244, subsection 35B was not met. There was no notice to cure. There was no mortgagee note for a loan modification. There was no notice sent to us, which is required, minimum 21 days prior to the sale. That was not happened. I happened to be home with my daughter, and, you know, my dad was home because he takes care of people, so he's in and out of the house, and we saw a car start pulling up, outbid, and I'm like, oh my God. And so we call a lawyer that we knew, and they were like, get outside, get outside, get outside, and that's when everything occurred. So we didn't even know that that happened. Had we not been home that day, we wouldn't have even known any of this had gone down until the sheriff had shown up at our house probably a couple weeks later with a notice that it had already occurred. And then the post-foreclosure, which I just touched upon, I believe was blatantly not in
Compliance.
state laws. You know, I do believe that they were not followed properly. I'm no lawyer, I'm just a single mom who's a bartender, but I have read up on these laws, and I just believe that, you know, then following all this and knowing all this and the guidelines, may I take a sip of water?
Yes, you may.
Okay.
Absolutely.
So while you're taking that sip of water, can I just ask, when we talk about having your day in court,
Yes.
and so the mortgage company presents documents, right?
Correct.
And says, this is, because the issue for the judge is, who has superior title to this piece of property? And so they present by documents saying, we did everything right, Judge. Here's what we call a prima facie case. Here's enough to say we did everything right. Then we turn to you and say, what do you have to say about that? And when I read through your testimony, you did touch upon many of these issues. But the judge didn't rule in your favor. So we would have to find that the judge made a mistake. Either just looked at the facts and was really like just wrong about the facts, or abused his discretion in interpreting things. Is there something in particular that you want, I know the time is up, but that you want to kind of highlight that you say?
Very much so, if you don't mind. In my record appendix, pages 26 to 27, it's not from the trial, it's actually from the appeal bond hearing, where it's the transcript where it shows that it was proven by me on counter
About Mr.
cross-examination
The perjury
that-
by Mr. Holt of going inside
that the affidavit was false, and Judge Michaud still agreed with David Holt and said that David Holt was correct when I proved in the cross-examination that he was lying, and a sworn affidavit was falsified, as well as in my record appendix 29 to record appendix pages 31, I pulled right out of the housing court judge being reprimanded for blatantly disregarding his judicial standings in the courtroom of what a proper judge and judicial law should be. And it's, I have the actual law that he broke in here. But he was reprimanded, and that was not soon after our trial. So it does make me question his due diligence, his integrity, his honorableness. I don't know if that's a proper word, to be honest.
We understand.
But it made me really question, and kind of a gut punch that someone could lie in an affidavit, it would be proven under another sworn testimony, and still be seen as okay by the judge to just go ahead. He did say in his judgment, and this is what I'll leave you with because I know I'm way past my time.
It's okay. Finish that point, and we'll move on.
He did say in his judgment, dated December 5th of 2022, there were significant issues concerning the validity and legality of the underlying documents. He wrote that right there, after also saying, which is in the transcript, that he used to work in real estate and he knows these laws. So why couldn't he uphold these laws in court as a sitting judge and recognize that things were not upheld by Massachusetts law standings?
Your time is up, but I have a couple.
I'm so sorry.
No, I have a couple of questions for you. So if you don't mind, I'm going to keep you here, and I'm sure our presiding judge will give the other side additional time if they need it. I don't know if you understand the legal term res judicata that he used in his decision, right? That just means that you could have brought it in your previous suit. Am I correct that you were not a party to the federal suit?
I
It's
was not.
just your parents?
I was not. I moved in with my parents when I got divorced and became a single parent.
So it's,
Then I was added to this.
I see. And who is the fourth person?
Katie McGillen? That's my sister, and she's sitting out with my daughter out there.
Okay, and she was not part of the federal lawsuit either?
No, when she moved home to help me
Okay.
raise my daughter.
And I have found the docket entry that says that the thumb drive was submitted to the court.
Thank you.
It says it was attached to a motion to dismiss, and at the beginning of the hearing, the judge, or trial, the judge also says, who filed this motion to dismiss? And it's you, or, your side of the case. Do we have a copy of that motion to dismiss in any of these papers?
So the motion was not to dismiss the case. It was to, we were suggested by the clerk's office to dismiss it to a criminal court using the thumb drive. After they already had the thumb drive and Melissa Rooney had looked it over, as well as the photographs when she was entering it into the docket.
Okay, I see. All right.
So it wasn't to dismiss the case, it was dismiss it from the Southeast Housing Court into the criminal court because she thought that the thumb drive carried enough weight for a criminal case. That's why that occurred.
Okay,
I think that's all I have.
okay.
Thank you, Your Honor.
Thank you very much. As I say,
Thank you for your patience with me.
well,
And you
we
just
know
stay
it's
now?
really hard when you're not a lawyer, so.
Thank you.
Good afternoon.
Good afternoon, Your Honors. Attorney Kelsey Bagg, may it please the Court, Attorney Kelsey Bagg for the plaintiff appellee, MTGLQ investors. I would like to start by just addressing, this is of course an appeal from a summary process trial, and I'd like to just address the arguments made by Ms. McGillen or Ms. Fopp, regarding the thumb drive first. As was stated by, I believe, Justice Vuono, the thumb drive was not submitted during the trial. It was not offered into evidence, and therefore it couldn't have been considered by the court. Nor do I believe that it could be considered, as it had never been, none of the information on it was identified. I don't know if that information was the information that was submitted on, to the appellate court, as I obviously have not viewed both of those items. However, again,
What evidence was submitted to the judge? Physical evidence?
Physical evidence submitted by...
Anyone?
The physical evidence submitted by the plaintiff, MTGLQ, was the mortgage assignments, the affidavits from pre and post sale, the deed and the related document, the deeds related to the document, and those were all marked as Plaintiff's Exhibit 1.
You don't dispute that the thumb drive was filed with the court attached to a motion to dismiss on September 7th, 2022?
I don't dispute that a thumb drive was.
It says a thumb drive was?
Yes, I don't dispute that.
You don't dispute that. So it's somewhere in the record of the case, but you say not submitted at trial.
Right, and I don't know what that thumb drive contained.
Well, I don't know why you wouldn't know what it contained. It's in the docket. Are you saying you were never served with it?
At some point, I believe that a thumb drive was mailed to our office as well.
I see, but you didn't look at it.
I did.
So you
review
do
it,
know
yes.
what it contains?
I don't know what was submitted to the court. I know what I know what I got a copy of.
Well, I don't understand what the difference is.
You can't testify as an officer of the court because you didn't see what was actually submitted to the court. You saw what you got. So you can't say...
Do you ever see the document that's submitted to the court when you get served with a copy, or you just know what your copy says?
I know what my copy says. However, you can also check the docket and view that it's the same copy. The same just doesn't apply to this thumb drive.
Okay.
So I would continue on just to say that I do understand that, testimony was submitted as to what was stated by the defendants to be in the videos and pictures that were submitted. However, that evidence, while it can be, the court can weigh that as they choose. Any of the testimony related to conversations or words from the auctioneer or any potential bidders, that would all be hearsay that couldn't...
Did you object on hearsay grounds?
Your Honor, I unfortunately was not the attorney appearing at trial.
Well, I mean your client, obviously, I don't mean you personally.
I am not positive.
Assuming that there was no objection by anyone at any time during this trial, your claim is that the judge couldn't consider the evidence because it was hearsay. But if hearsay is not objected to, it can be used for its substantive value, correct?
I'm sorry, I had a hard time hearing that.
So hearsay, if objected to, could be inadmissible. But if there's no objection and the testimony comes in, it can be used for its substantive value, correct?
For what that value may be.
Right. So if there's no objection and it was testified about what these conversations were, the judge could weigh that, correct?
Correct. However, in this instance, that evidence was presumably weighed by the trial court judge and weighed against.
Where do we find that, though? I mean, I've read the trial court judge's decision numerous times. Maybe not as many times as each of you have read it, but I've read it numerous times. It just says, you made a prima facie case, and res judicata, and possession to you. Where does it say, I've considered the defense about the improprieties about the foreclosure process that have been presented by the defendants, and I either credit it or I discredit that evidence?
That may not be written out in the findings itself. However, the judge took the arguments under consideration at the trial.
Well, the judge actually said he wasn't going to consider it, right? At the hearing, he said, I'll look at the foreclosure papers.
Don't believe it was stated that he wouldn't consider the arguments at trial. I do know that the judge stated that he found that no answer was filed, and instead there was a motion to dismiss that was filed that was heard and ruled upon prior to the trial moving forward.
But case law is clear, even without an answer, a defendant has every right to bring a defense. As to the challenge whether or not you hold superior title. I mean, it's your action. You're claiming, we own this house, we have superior title. They have a right to present a defense as to why you don't, right?
Right.
Whether if they file an answer or not. Always helpful if they do, but if they don't, they can still go forward. In Massachusetts, we don't allow possession by default, right? We allow a trial. And so that to me, so I'll just put it out there. This is a difficult case. At least it is for when I look at it, in the sense that there appears to be admitted fraud that can't be considered. And then there's evidence of recent fraud. Would you agree would you agree that if the auction was done in a way as described, that potentially could invalidate your claim of title?
I'm sorry, is the hypothetical that what's described in the...
About the auction. If what was described about the auction was true, that it was fraudulently done, and that it wasn't open to the public, and the highest bidder really didn't win, it was all in the fix, right? It was fixed. It was from the beginning to the end of 45 seconds. It was already predetermined. Whatever outbid wanted to pay, outbid was going to get for this house. If that's true, would that have an effect on whether you have a valid title to that property?
That if that were true, that would be a different set of circumstances, Your Honor, but that's not the set of circumstances here.
So were the defendants entitled to present that defense at trial before this judge?
I believe that defense was presented.
And so your position is that the defendants had a fair opportunity to present their evidence on the issue of a fraudulent auction, and that the judge, although he was silent in his factual findings, didn't find it convincing.
That is correct, Your Honor. The arguments were made, and I don't see that the trial court made any clear error in the findings of fact.
But how do we know when I understand that the trial court, there's no requirement that detailed findings of fact in a summary process action happen. But how do I make that inference when there's nothing? So in other words, when we review for whether the judge made an error in the facts, right? Then we look at the facts and say, okay, no, that wasn't true, that was right, or that was wrong. When the judge is silent about this defense, how do we know whether the judge weighed it properly or not?
I don't believe that any evidence or argument has been made to show that the judge did not. I'm not simply the only real argument related to those items that were, not able to be submitted is simply that they weren't considered, but not that they were ever even attempted to be submitted for the judge's consideration. And as such, the only thing that was available to the judge for consideration was the testimony.
And so you agree that Ms. McGillen, or is it Fall, presented testimonial evidence of the improprieties of the auction?
Of what her, the interpretation of that was, I suppose.
Okay.
Can I ask a couple of questions? Presumably, the res judicata portion of the judge's opinion does not apply to things that happened after that case, so it doesn't apply to this question of the foreclosure process or the
sale
auction itself, right?
Sure.
Only two of these plaintiffs were defendants were parties to that case. Why is res judicata applicable to the other two?
Your Honor, the other two defendants are they're residents of the property. The mortgage contract was between MTGLQ as the current holder at that time and Amy and John McGillen as the property owners and mortgagees.
Okay, but these were not issues that were decided. It's not like collateral estoppel where they actually litigated these cases. They're res judicata because they could have been brought in the original lawsuit. But two of the defendants were not in the original lawsuit. They couldn't have brought them.
They wouldn't technically in this, this as the foreclosure can be challenged. The owners of the property, however, were Amy and John McGillen.
Okay, but in a summary process action, you bring an action against people in possession. They may or may not be the owners of the property, right?
They are also they were the former owners of the property, yes.
The two children were?
No, Amy and John.
Okay, I'm asking about the two children who were not part of the suit. I'm trying to figure out why res judicata would bar them from raising these claims about what the judge himself called, apparent irregularities with respect to the origination of the mortgage.
They were not parties to the mortgage, so I'm not sure that they could ever bring those claims.
But if your title is no good because of that mortgage being no good, and they're in possession, why can't they defend against summary process by saying, I don't know who MTGLQ is, but there was never a valid mortgage here?
I would argue that was raised previously by the
Yes, but
proper
not
parties.
by the people, not by all four of the people you're trying to regain or gain possession from, right?
At that point, Your Honor, it would still apply that those claims are time-barred.
Well, I'm not sure if, we frequently have people in summary process actions bringing up issues about the mortgage itself that might have been 20 years ago. I don't know what the rule is about bringing it up as a defense to a summary process action.
A fraud claim as to the origination would be time-barred.
It's not a claim, it's a defense.
Process, right? So had this family, these homeowners, not filed suit affirmatively, and then it be transferred to federal court, and however many years later, your client comes in and says, hey, we own the property, they would have every right to make a defense of, no, you don't have superior title because that whole mortgage was a fraud. It happens all the time in summary process cases.
I would not agree that that would, again, I believe that that argument would be time barred if brought as a defense.
As a defense? Defenses can be time barred?
The argument, the fraud argument is, as stated by the federal district court in their opinion, was time barred.
Well, that was a suit by the parents. They can't bring the claim if it's time barred. But this is a defense to your claim that you own the property.
I would, at that point, I would then argue that none of that was really raised at trial.
Okay. No
That's all I've
questions?
got.
Judge Walsh, do you have any further questions? The panel doesn't have any further questions. We had plenty for both of you. Thank you both very, very much. We appreciate your helping us out with sorting through these issues. So we'll take the case under advisement. All right? And are you okay leaving the courtroom, do you think? There's a court officer here if you need any assistance, all right?
Thank you.
Okay. Thank you both very much for your arguments.
I get really bad.
Okay, and in a moment, we'll let those that are here leave the area, and then we're going to hear the case of Crown Communities versus Philip Austin and another, 2023-0580.
Thank you very much.
Okay. All right, so the lawyers for the last case on the list can come forward, please. All right, we're ready to go.
Thank you. Good afternoon. May it
Good
please the
afternoon.
court. My name is Tom Ellsworth. I'm the attorney for the appellant, Pocasset Park Association, Inc.
You can introduce yourself when you start. It's no problem. You can take a seat. Thank you.
I'd
Go
like
ahead,
to
sir.
start with the issue of first impression that's presented in this case, and that is the meaning of the words reasonable evidence in the context of the Massachusetts Manufactured Housing Act as it pertains to the right of first refusal for clients like mine, residents of such communities, to exercise the right of first refusal. That's an issue that's central to this case. It's an issue of first impression because it's never been raised before, as pointed out by the amicus letter filed by the Attorney General. It's an important issue in this case because one of the key requirements of the statute for the residents to exercise their statutory right of first refusal is they have to submit to the owner of the community reasonable evidence that the residents of at least 51% of occupied homes in the community effectively support the exercise of the right of first refusal.
What are you going to do? Could you address the fact that the judge actually found after hearing trial that there was no credible evidence, let alone the definition of reasonable evidence, right?
That's right. The judge did find that, and that's why we're here.
Well, I realize that, but in other words, you're also here saying that there was a case of first impression with respect to how we're going to interpret reasonable
Yes, Your Honor.
evidence, right? So here we have a situation where judges ruled there is no evidence. So I figure no evidence is pretty clear, whereas how do we get to reasonable, is my question, in your view?
Thank you, Your Honor. So the first step is to look at the regulations promulgated by the Attorney General. Those regulations provide that reasonable evidence include, without any limitation, a writing signed by the residents. That's the
When
first
you say
step.
residents, what do you mean by residents? Do you mean resident owners or just residents?
Just residents, and we can talk more about resident owners, but just residents, because that's what the statute says. The first part of Section 32C, when it talks about the organization, that refers to owner residents. But the requirement of the support of the reasonable evidence, that's the next clause, and that says residence. It doesn't say owner residence. And that interpretation.
So just so I know, that means basically, obviously, a resident, anyone who's living in any of the manufactured homes.
Yes, Your Honor.
Correct?
Yes.
Could be visitors, could be tenants, could be subtenants. It doesn't really, do you define residents?
Either owner residence or subtenants.
Okay, not visitors or temporary tenants or anything like that.
Not transient persons living in
And
the
how do you
community.
know if they're transient or if they're subtenants? Or
Well,
tenants,
that's an
et
excellent
cetera?
question. And that goes to the evidence that was presented. Because what's important is the person who knew in this case was the owner. The evidence at trial, and Mr. Austin testified, the owner, the evidence was that first of all, he's the keeper of the rent roll, so he knows who the owners are. Second, he testified that he's in the community every day, and he gave extensive testimony about his knowledge, detailed knowledge.
Did he mention most of the people, those who were still there, those who lived in Florida, those who had unfortunately passed away, et cetera?
That's right. What's interesting about that testimony, of course, is that's as of the date of trial. Well, the relevant time
Would have been much earlier.
would have been in two and a half years earlier. But he knew, Mr. Austin knew, and his testimony was pretty convincing about that. And he testified.
Well, actually, but the only, if I recall, what you're really relying on is the fact that Mr. Austin accepted the representation that there was over 51% of the residents, not that there was any kind of a comparison or a detailed look or anything like that, right?
That's correct, Your Honor. So the point is.
That's enough, you think? Your point is that's enough?
I do. And the reason is because he got the petition, he reviewed it with counsel who the testimony at trial was. His attorney at the time is an attorney who represents many owners of such communities, and the testimony was even that from one of the persons who's employed by a nonprofit that works with these communities, including Pocasset, that Mr. Austin's attorney actually in other cases had objected to petitions because of questions with the signatures. That didn't happen in this case. So Mr. Austin got the petition, he got advice of counsel, and he signed the association
It
TNS.
seems to me difficult to say that reasonable evidence is sufficient that an attorney reviewing documentation gives advice to a client, that amounts to reasonable evidence.
Well, I hear your point, Your Honor. Note that in the Attorney General's amicus letter, the Attorney General says the bar is very low. And that is consistent with the purpose of the Act, which is to not make this difficult.
I agree. So let's go with that. So the bar is low, right? But we still need to have a bar or a definition, right? Okay. So let's say, hypothetically, that the opinion of a lawyer advising a client, we don't really know much about it. Of course, we know nothing about those conversations. We don't really know how that actually came about. All we know is that, yes, there was an acceptance of this representation. So let's say we reject that does not amount to reasonable evidence. What else is there?
What there is the testimony by the owner, because the objective standard here doesn't exist in a vacuum. The objective standard has to also consider the circumstances under which this petition was considered by the owner, and we've already talked about that. It's that the owner knows who the people are who reside in the community. He knows that, and if he has a question about the signatures or whether it's reasonable evidence, he has time to make a challenge and to ask
Why would it be there? Why isn't it the judge who makes the determination if there's reasonable evidence? It wouldn't be the owner who's in charge of that, right?
Sure, but I think the circumstances that I'm discussing all have to be considered by the judge, because it's not just take a look at the petition and in the four corners is that reasonable evidence. The judge has to consider the fact that Mr. Austin had such detailed knowledge of who was in the community, who the owners were, who the residents were, and the judge didn't do that in this case. The bar
I'm
has
sorry,
to be low.
I'm not sure, I mean, I appreciate that there's all this stuff. Why aren't the signatures reasonable evidence that the people who signed it want to have the association buy it? Why do you need more than a signature? Now, I understand that in this case, like in some other circumstances, a number of the signatures were challenged, and in fact, the judge found there's 4 duplicates or whatever. He was looking at one point at only owner residents and found some were not owner residents. But why are we requiring more than signatures of residents as reasonable evidence that they, on a petition that says, please do this?
Well, of course I agree with Your Honor, and I think my point, I don't want to be unclear about it, is if there is reason to challenge, because there might be, and we know from testimony in other cases there are, the owner can do that. Short of that, the signatures, according to the Attorney General's amicus letter, should speak for themselves.
Well, the owner, in fact, I mean, in this case, it's the Crown community, the original offeror who is contesting it. It should be a matter of indifference to the owner who buys it, right?
Correct.
It's going to be the exact same thing. There's a preference in the statute for the people who live there being able to buy the land underneath their manufactured housing. But the owner shouldn't care one way or another, right?
I think that's right.
Okay. Now, but in this case, it was contested by the by community, Crown community, and they put in, presumably, evidence that challenged some of these signatures.
That's right, Your Honor, and the judge accepted that evidence and did the math. The problem is, of course, as you know from our brief, the judge did the math wrong. The judge concluded that there were 49 signatures on the petition when in fact there were 61. And when we filed a Rule 59E motion to give the judge a chance to correct the error, the lower court did not do that. Instead, what the lower court didn't even address it and said, well, the association didn't meet the verification standard, so that's it.
But let's back up for a minute, because
Yes, Your Honor.
I don't want to conflate two things. When you talk about the petition, you're talking about actually the petition that's later signed that has to do with exercising the right of first refusal. You're not talking about the initial finding that has to be made that 51% of the park's owner residents have joined an association.
That's
right?
a different issue.
Exactly, and that's the first issue.
Correct.
Really.
That's the first issue that was addressed by the judge. That's
But you have only been addressing the second issue so far, if I'm...
correct. Yes.
That's what I wanted
Okay,
to
yeah,
yes.
okay.
Okay.
But let's move on to that. The point is that the statute doesn't say that there has to be 51% of the resident owners who are in the association. What it says is that a group or association of owner residents representing more than 51%. It doesn't have to be an association. And it's
Okay,
that,
but it
yeah.
has to be 51% of owner residents.
That's correct, Your Honor.
Okay.
Yes.
And the judge says there's no credible evidence of that.
He sure did.
Okay. And can you point me to your credible evidence of that? When you're looking at just simply the pages of that were submitted as an exhibit at trial of the signatures?
Well, Your Honor, I don't have the pages of the appendix in my outline, but they're in our brief.
Mm-hmm.
And those pages of the appendix that are cited in our brief. The brief also tells you it's the testimony primarily of Nora Goslin. She is another member of the nonprofit organization that goes around New England and helps these communities. She testified that she was responsible for the membership list, that she based the membership, which was in evidence, by the way, the membership list.
But she was quite clear that she just assumed. Her testimony was fairly explicit. I'm confident, I'm sure there are that many of them. How do you know this? She was asked, and she did not have an answer.
She said that about the second requirement on the
All right,
petition.
then I
On the
stand-
first part
okay.
on the first part, her testimony quite expressly was she based it on the rent roll. That's kept and produced by the owner. That shows who the owners are. That
Okay.
shows who the owners are. And that's
Can I also say, I find this very confusing. The judge seemed to require 41, well, 41's the wrong number because there are some non-resident owners, but more than 50% of the owner residents to be members of the association. That's not what the statute says.
That's correct.
It says an association of residents representing at least 51% of the manufactured homeowners, and the petition shows who they represent, and they represent, if there are more than half of the owners on that, then they represent more than 51% of the owner residents, is the way I read it.
And the way I read it, thank you, Your Honor, you just made my point. And if you, even using the judge's math by discounting those 13 signatures he found not to be credible, you end up with 48 out of 81 occupied homes. Those 48 signatures, it's not 2 signatures per home, that's 48 signatures of residents of 48 homes out of 81.
But
that's
also,
over half.
also, since he knocked out the residents who were not owners, presumably that number is all owner residents.
Yes, Your Honor, that's correct.
I'm not sure the number is the same as the number on your list of 40 of 55 or whatever that is, and I don't understand that. But the judge found that there were 35 owner residents who had signed this, but he missed 12 of them.
That's right, Your Honor.
All right, so then, I guess this is what gets us to this question. Then he says, in the 59E order, as I read it, he says it doesn't matter. He doesn't say, I didn't make a mistake. He doesn't quite say, I did make a mistake. He says it doesn't matter because these aren't verified signatures. But
That's right.
Why is he saying, I mean, maybe this is more for your brother, why do they have to be verified signatures?
And our position is, along with the Attorney General, that they don't. That's a bar that was created by the judge. It's not in the statute.
I think Justice Walsh had a question for you.
I think I know the answer. I just want to make sure I do. Your argument is that, I won't call it simple, but a mathematical error was committed by the judge. So long as we accept your argument that on this petition, we can consider both owners and
Residents.
lessees or renters
Yes.
who reside there. So as long as we accept that principle that owners are not, and renters have a right to put their name in there, to be included in that 51%, that this is a simple mathematical error.
While that is true, we show the math both ways because the judge pretty much asked us to. So we did it both ways. But yes, Justice Walsh, that is correct. I see my time is up. I had a couple of quick points I'd like to make about our new arguments in their brief, but I understand if I don't have time, I don't have time.
Did you not file a reply brief?
We did not file a reply brief, and that actually, this is a case about limited resources on my side, and that's not the case for the other side.
All right, let's give you 2 minutes.
Thank you, Your Honor. 2 quick points. One point, I believe that it's made for the first time on appeal, is that the right of first refusal does not apply in a case where the sale is to continue the same use. Just to make it short, that argument was soundly rejected in the Greenfield case. If the court takes a look at the Superior Court decision, is quite good on that. And that's at 3 Mass Law Reporter 348.
You're going to have to say it one more time and a little bit more slowly.
3 Mass Law Reporter 348. It was affirmed by the SJC in 1996. And then there's, the next point I wanted to make was about the substantially equivalent offer argument made by Crown.
Yeah.
The argument by Crown is that my client's offer was not substantially equivalent because
You had a mortgage contingency and they had cash, and so.
Thank you, Your Honor. And so the point is this. The statute includes a provision that says that the association has 90 days to obtain a financing commitment. If what Crown is arguing is true, that makes that part of the statute a nullity. Furthermore, I would say...
Well, no, it wouldn't be a nullity because you could still have a mortgage contingency in one PSA and also in the other one.
Yes, but what would happen, of course, is that every developer who wants to buy one of these communities can have as long as it wants to set up its financing in advance. My clients, they have 90 days, and it's just... And it's just, there's no way that they're going to be able to get it in advance. So it totally...
Is it usual in terms of investors who want to buy these kinds of properties, that they usually offer a cash only and not a mortgage contingency? Because I didn't seem to pick that up during the testimony.
In my limited experience with a couple of these, the answer is yes, but I don't have that much experience. But the point is, if that is the result of this case, any developer will read the decision and understand, all I have to do is come to the table with a cash offer and there's no right of first refusal. That cannot be what this statute was intended. And with that, Your Honor, thank you. Oh, also, the Crown did file a motion to file a reply brief. I asked it to be stricken or at least given some time to reply.
We'll take all those motions under advisement.
I have one
Justice
more
Rubin has one more
question,
question
even though
for
your
you.
time is up, and I assume again that
Go ahead.
our panel chief will give the other side additional time. This commitment to keeping the use the same, how long is that binding for? Forever?
It's not binding forever, but there's a very particular provision in the Act that has a very high bar for the owner to cross in order to discontinue the use.
I see, okay.
Thank you.
Thank you very much.
Good afternoon. My name is Walter Sullivan. I am the counsel for Crown Community Development, LLC, the appellee in this matter. May it please the court. I'd like to go in order, if I may, but a couple of things that I think are important that the court asked in its question. The owner of the park very clearly testified that the rent roll did not constitute his understanding of who the owners were. It was who paid rent. Mm-hmm. So reliance upon that is misplaced, is our position. But with respect to the statute, I think it's pretty clear, a careful reading of it is, in order to trigger the right of first refusal where the park is not going to be discontinued as a manufactured home community, that 51% of the owner residents have to demonstrate that they want to exercise the right of first refusal. The court very clearly found that didn't happen here. So although the appellant wants to go right to reasonable evidence, they don't get there if they can't prove that the court was clearly erroneous in finding that there was insufficient evidence.
And they say it's clearly erroneous because there is an absence of counting 12 additional people.
There is that. So, and I guess this is where I'll go to the evidence that was presented in court. So the petitions don't get them the 51% resident owners. And I would like to also point out to the court, as I'm sure it's well aware, we established, because we were confused as to how they were going to prove their case, with a motion in limine, the burden is on the association. Mm-hmm. They have to prove this. And so it was very clear when we started this 5-day trial what was required by this judge. So the first thing they had to establish was that they had 51% of the resident owners, and the testimony came in unrebutted by the owner of the park. That rent roll of December 2019 is not the owner.
The judge found 35 owner residents had signed the petition.
I'm going to interrupt and be sure that we're talking about either the association or we're talking about the petition.
Figure out which, yeah.
Because if we keep conflating those two, our answers are not going to be clear. So I think, were you referring to the 51% of resident owners to establish the association, or were you referring to the petition?
I was referring to what was necessary to get to to see that before you get to what the AG is talking about in her amicus letter, you've got to establish, because I'm not discontinuing the park, you've got to establish that you have 51% of the resident owners who want to buy it, and they can't rely on the rent roll.
Who want to buy it, not who are members of the association, right, but who want to buy it.
Right.
Okay, so the petition includes signatures of lots of people who are saying, because this is what it says, we want the association to buy it. The judge looks at that list and knocks off a bunch of people who you appropriately challenge. The judge says 4 of these are duplicates. The judge says some number of these, it's 2 people in the same house. And he's not going to count that. I don't know if it counts or doesn't count, but let's say that's correct. And he says, and these ones, 5 of them I think, or 4 of them, these are not owners, they're just residents. and all that's left is 35 resident owners, never mind the rent roll. This is what the judge found as a fact. And I take it your brother is saying, and that's clearly erroneous because the denominator he was using of 49 is wrong. There were actually 61 signatures, and when you knock his out, instead of coming to 35, you come to 47.
And my point, Judge, is I agree with what you're saying, and yes, that's clearly his position, but my point is, it's not a reasonable evidence standard or a scrap
I
of
agree
paper.
with that. I agree with that.
And
Just
so
go with the numbers.
the burden is on them. Prove to me who the owners are, and quite frankly, Judge, it's virtually impossible.
The judge found 35.
That's what he found.
All right, and so now if he had, there's a math error, right, in that. I don't know if we all agree on that, but it looks like there is to me.
Well, do we? Is there?
Do we agree?
What do you say about this? About the allegation? There's a math error.
I don't disagree that the numbers don't make sense, but what my point is, and I'm not articulating it well, is that the burden was on the association to show that it had a sufficient number of resident owners, and there was a credibility challenge, and it was because they didn't meet that burden, this reasonable evidence standard never should have been triggered.
Okay, but
and that's what I thought the judge was saying.
But, all right, so the judge, of course, at first says nothing. He just makes this math mistake, right? He just says it's 35, thanks for coming in, but 35 isn't enough, okay? And I guess I'll assume that's true. I assume there are more than 70 owner residents. I'm not sure how to figure out, but you only knocked out 4 or 5 of them as non-owner residents. So now, maybe instead of 81, maybe it's 77 or 6 or something, and 35 isn't enough, but 47 would be. Now, in a 59E motion, this is the first time this appears before the judge is asked, hey, you left out these 12. Judge doesn't deny it or admit it. The judge just says, oh, but these aren't verified. And I take it your position is they have to be verified signatures because we're not using the reasonable evidence standard. We're using a preponderance of the evidence standard. And I guess I don't understand how he thought 35 was good enough at the time of the trial. Now he's challenged for having made a math error. He says, yeah, well, okay, but it's not the standard I used at the trial. It's really verified signatures, or I don't remember, sworn or verified. Now, we don't require sworn or verified signatures for people to register to vote, to sign a ballot initiative. You know what I mean? People challenge them, but you don't have to show that they're sworn or verified before someone comes in and says, hey, I disagree.
But here, Justice Rubin, here the trial judge had credible challenges testifying about the way the signatures were gathered. The owner saying, I don't believe these people are all owners or residents, and the whole process was impure. Moreover, reliance on requests for admission that came in but not into evidence, all of that wasn't before the judge.
Now you're saying these aren't credible signatures. The judge had never said that. The judge said they're not verified, they're not sworn to, so it's inadequate. But he didn't say, and they're forgeries or made up or strange people did it. He actually went through one by one and said which ones were not adequate.
I will represent to the court, there was evidence about forgeries before the judge, and I think
Let me
yes.
ask the question just a slightly different way.
Sorry.
So we can understand. So 35 signatures are accepted by the judge. 4 maybe that withdrew, so let's put that in parentheses, right? Okay. What was different about those 35 signatures of resident homeowners that the judge accepted and the 12 signatures that are in controversy right now?
So I think what the judge was saying, in the best case scenario, you might have this, okay, if you meet all these other criteria of the
I would want to know, in the transcript, in the 5-day trial before the judge, what was different about the evidence that was presented of the 35 that the judge accepted and the 12 that were apparently appeared to have been left off when he issued his findings and rulings, brought to his attention later on, and he did not accept those. What was the difference in the evidence in those two groups?
The appellee came forward with some people that had signed it and said, that wasn't my signature. I didn't understand the process. That's not what I intended.
In the 12 or just throughout the list?
So we didn't present 12 in contrary, Your Honor. And the reason for that is our position was we don't have the burden of proof. We gave the judge reason to question the reliability of the petitions, of membership agreement list that was dated 2/28 that did nothing to establish that they were exercising the right on 1-2.
But how is it that the burden of proof was met or not met, so to speak? It was met, actually, for the first 35, right? They met the burden of proof, whatever you want to call it, preponderance of the evidence, whatever, for the first 35. How did they, what was different about those 12? Because I didn't see those 12 names individually discussed.
No, I think in our brief, we characterized the strategy of the appellant as the minimalist strategy. Here's our signatures. This is what we've got. This is what we've got. Other than 2 officers on the board, the appellant presented no testimony to verify signatures. That was it.
But your answer to Justice Vuono's question is, there is no difference. It's not as if among those 12 there were also 4 duplicates that the judge didn't consider, or they weren't, those signatures were not particularly described in any way different from the 35.
I don't disagree with that proposition. I will say there were 5 people on there that were deceased at the time of trial. I think he gave credit for that. There's a whole category of challenges and questions and issues with the signature, and the judge made his findings, and I'm not going to represent to the court. I know exactly what he decided.
I'm not asking you to do any more than what's in the record here, but if the judge did not specify what the reasons were for there being sufficient proof for the 35, but not for the 12, what do we do with that?
So
do we send it back?
So I think that it was a harmless.
I didn't think you wanted things.
Obviously, Justice Vuono, our client's position, if that is the case,
is that they didn't meet their burden then?
It was a harmless error because there's 4 criteria they have to meet, and they didn't meet any of them. They don't have a purchase and sale agreement that's substantially equivalent to the one we submitted, and they didn't get their financing within 90 days.
Okay.
And so, for those 2 reasons,
I'm sorry, you got a lis pendens on the property.
I'm sorry, Judge.
You got a lis pendens on the property. How are they supposed, who's going to give a mortgage on a property with a lis pendens on it?
Judge, there's absolutely no evidence that that's why they didn't get it. In fact,
in all honesty, are we really, this statute is designed, frankly, to prefer ownership by the residents of these parks than to prefer your ownership, your client's ownership. That's why it's there. There's a 90-day finance limit, but if we allow the party against whom or over whom they're given precedence to get a lis pendens on the property and then complain that they didn't get their financing, how is that going to work? Now, I can't tell you for certain that that's why they didn't get it, but how can they have to get it when there's I don't know that much about this. I don't think you can get a mortgage on a property with a lis pendens on it. Maybe if you're the best customer of the bank and you go in and say, like, look, I just need a commitment or whatever if I can somehow get this thing off. But
2 responses. One is they got a mortgage commitment. It was belated. So the lis pendens didn't impact that, Judge. I think that was overwhelmingly apparent. So I would disagree with what the appellant counsel said here today, that there would never be an opportunity for them to move forward if they don't have a financing commitment. The evidence at trial was that CDI was funding this. CDI had given them $100,000 just for due diligence. All of this was being financed, the purchase price plus as the court can see from the record, the construction. So they were able to get financing. There's no evidence that they were unable because of the lis pendens. There's no reference to it whatsoever. I would agree you can't close, but CDI is in the business of helping homeowners buy these parks. I think the purpose of, I'm sorry, Justice Walsh.
Can I just interrupt for a moment? Because you're saying, it's harmless error, and I'm not so sure. But what I'm also not so sure is this. You don't want it remanded. That I'm sure of, right? That's okay. I understand. But aren't we entitled to look at the record and say 12 plus 35 is 47 divided by equals more than 51%? Maybe we don't need to remand it. Maybe we can make a mathematical adjustment based upon the undisputed facts that are before us. Can't we?
I respect that this court can do whatever this court chooses to do, but I would direct this court.
That's a good answer.
I would direct this court to pay careful attention to their failure to meet burdens 2 and 3 of the statute. They did not have an identical purchase and sale agreement, and it is completely false.
But going back to the math,
Yeah.
aren't we in as good of a position as the trial court judge to take a look at the evidence that is before us and to make that determination? Now, maybe even if they get to 51%, you're going to say, but they failed on 2, 3, 4, et cetera. I respect that position. But can't we do that?
This was a confusing case, and the statute is not the most easy to digest. And I would welcome this court to do that, and obviously it has the authority to do so. But I do want to make one point, if I may, and I see that my time is running.
You have time. Go ahead.
On the purchase and sale agreement, it's disingenuous to say that you have to have a mortgage contingency or else every developer can take us out. People finance transactions and don't have a mortgage contingency. Businesses, nonprofit organizations, and private individuals. So that's part of the bargain. And it's so important for the court to recognize here that we accept that the purpose of the statute is remedial and to protect people so they can stay in homeowner parks and in manufactured home parks, but we are in the manufacturing home ownership business. There was absolutely no evidence that we are going to convert this park. In fact, we're not. And that's why it should be a lower standard. That's why they have to meet their burden of proof. And to the Justice Rubin's question, to transfer it under the statute into something other than a manufactured home community is incredibly elaborate, time-consuming, and there was no evidence my client was ever going to do that. So,
but that's not really, I mean, I appreciate that, but that's not really the question. And when you say, I fully agree with you that if this were a private transaction where there was a right of first refusal, we would easily say, because the standard's different, it's not substantially the same to have cash and a mortgage. But this doesn't say substantially the same like our case law does. It says substantially equivalent. And I assume that equivalence is not for your benefit, but for the benefit of the Austin Trust, who's the owner. And it just seems to me that it's the idea that we're going to have these disadvantaged by hypothesis. I don't know anything about this particular park or its residents or anything, but in general, the idea is these tend to be populated by less resourced and less well-informed people, and this is giving them a chance to own the land under their houses. And the idea that they have to be, if the developer comes in with cash, or not developer, new purchaser, that they have to come up with cash, right away, and make an offer that they have cash when they don't, and then run the risk that they breach that and so on. I mean, that doesn't seem consistent with the idea behind this.
well, Judge, the way I read the statute, it is to preserve manufactured home communities. And here, there's no danger of this manufactured home community going away. It's just going to be a new owner who's going to inject cash into it. With respect to the option, I think that the option is for the benefit of the seller of the property. And I think the standard is, does it impact the seller? whether they want to accept a financing contingency or a change in the purchase and sale agreement. And Mr. Austin testified quite clearly it was a difference of significance to him. They weren't just financing 100% of this, they're financing like 150%. This was a significant difference, and it's in the statute for a reason, substantially equivalent. Clearly, a mortgage financing contingency is important. It's not the same or substantially equivalent as the deal that my client offered. So for all those foregoing reasons, we would pray that this honorable court affirm the judgment of the trial court judge, and especially as to the counterclaim, which hasn't been discussed here at all. But this was clearly a lawsuit brought in good faith. It was a petitioning activity protected by the Commonwealth of Massachusetts for someone to enforce their contractual rights, not a violation, tortious interference, or 93A, or any other statute. So we pray this court's judgment. Thank you.
Well, thank you both very much. Thank you for your arguments and your briefs, and to the extent that there's some housekeeping matters, some motions to reply and to file a response to the amicus letter by the AG, we'll take that under advisement. All right? Thank you. Okay. Thank you both very much. Court stands in recess.
All rise.